the excise notification, the virus of the excise notification related to tobacco rate and the new health security, National Security Act. But I will only bring kindly turn this matter anytime as per my lord's convenience in this week, because otherwise I'll have to comply with the provisions of this act. The virus of these provisions are challenged.
But virus, how will virus be decided in such a short time?
Obviously,
but then prima facie satisfaction has to be there that it's ultra virus.
We will argue that it is a good case for stay, as I had indicated on the last occasion, my lord. One of the competitors, they have already obtained stay from the Honorable Karnataka High Court, but that order is in personam, it's not in rep. So, my lord, I'm in a very precarious position, my lord, at least for the purposes of stay, anytime as per convenience of my lord.
774775 একটু দেখাবেন চেম্বারে নিয়ে let us see when we can give.
One more matter, 771, which also I mentioned last week. Now, this I requested for upgradation. My lord, and indicated on the upgradation list is quite heavy. So I pray that let it come in the upgradation
list. It will come. Let us see 774775. That can wait. 774775 একটু ফাইলটা দেখাবো.
I've written 777. I've written to the adjudicating authority that my witness is in the list, but kindly await the adjudication.
My lord, may I permitted to mention one matter, my lord, urgent matter. My lord, your petitioner is a small contractor working in the Panchayat level, my lord, constructing, my lord, culvert or etc. My lord, he regularly paid GST. My lord, once in separate.
What is the challenge, sir?
Or the challenge, my lord, his account has been blocked by the GST authority, bank account, my lord. Therefore, his business has been choked, my lord. He is a small.
Very well. Please wait. Next week. Please mention next week. Next week.
Lordship, yes. May I kindly mention item number 163, my lord, read petition pending from 6th May, my lord, and order passed in the name of deceased person, my lord. Now they are asking, my lord, that I submit stay order or either or my lord, they will proceed for recovery, my lord.
Please wait. Next week.
My lord.
Yes. Lot of matters are already
yes,
there.
yes,
Let me
yes,
finish some matters then.
Yes, my lord, may I be permitted to mention the item number 766? The petitioner cannot run his business due to his bank attachment of bank.
Yes, please wait. Next week. Next week.
May I have others kindly to mention upon notice below, this is an upgraded matter, item 70 running in the list. It relates to, my lord, pan masala. My lord, from today, the rates have changed. So, my lord, these are confiscated. My lord, these are goods which are held back. My lord, the prayer is, my lord, to release the goods immediately, because, my lord, from today, the rate of tax has become from 28 to 32%. So, my lord, 34%. So, my lord, these goods, thereafter, we will not be in a position to sell these goods, my lord. I'm only praying, my lord, if that can be taken up at any time that is convenient.
It's already upgraded, Mr. Bag.
It is, my lord, but then
cannot upgrade it any further. Let us see.
My only prayer, my lord, because otherwise we'll not be able to tell of these.
Because everybody argues for 1 hour, so I cannot proceed.
I understand that.
So if you limit your arguments, I'll be able to move faster. Yes.
May I only pray, my lord, if it can be listed anytime
there, Mr. Bag, it cannot be upgraded any further. It is already upgraded. No
maybe
more
try, my lord, if it is not in the couple of days.
It's difficult. I have accommodated everybody. Now I have to be very strict even in mentioning, because I see it's getting expensive.
So we'll wait. We'll await our turn. I understand that.
Cut shorts the arguments. Everybody wants to argue for 1 hour, so it becomes difficult for me also.
Indeed.
I have limited time.
Indeed, madam.
In that I have to pass order. I cannot keep all the judges at TAV.
I understand. In case, madam, we'll try again, madam. I'm very deeply obliged.
If I don't get that cooperation, it becomes very difficult.
Indeed, madam. Deeply obliged.
Please wait. Yes. That everybody says. What is your matter?
I am a victim of cyber fraud. Some notice came from Chennai and my bank account is free. I have replied to the GST council that I am nobody, but you know GST. I also lost a complaint that my bank account is fraudulently by somebody else and my bank account is free by GST council.
Please wait. Next week. Next week. Sir, don't you understand, sir? I said next week means next week. Yes. Please. Next week, madam. Next week. Yes.
This matter, this is cooperative society, but parking services which is exempt from GST. Order has been passed on 21st of January 2025, and we filed a petition on 24th of April 2025, which has never been heard. Now, my lord, my bank account has been frozen. I am unable to pay my salary to my.
Next week, because already lot of matters are
I
there.
understand, but this is a very old matter. Otherwise, my lord, I
What can be done, Mr. Sharaf? Let me finish some matters. There is no use adding it up. There is no use adding. Next week, please mention you have waited for 2 years. You cannot wait for 1 more week. 1 more week, please wait. I have said that to everybody. I'll not make any exception.
No urgency. So this is not.
So very well. So if urgency has arisen now, please wait for 1 week. One more week, nothing will happen. Let me organize the list once.
My lord's praying for inclusion in the list.
Extension of interim order, please give. Inclusion, please give. Inclusion, please don't mention. Let the list be called now. For why, sir?
Because my lord, I are out of the order of body or challenge, my lord. Amount, my lord,
Upgradation next week, not now. This week I am not allowing. Let some matters be finished. Lots of matters have been upgraded because people are coming and mentioning upgraded matters. For further upgradation, it becomes difficult now. Madam, next week, no mentioning. It was not directed to go out of list. Because last week several matters were directed. Those won't be included.
The bench has transferred matter, so the matter is not considered.
It pertains to which year? 23, I don't have determination.
Your Lordship, may I be permitted to mention one matter? I had mentioned this matter, Your Lordship, previously.
If you have mentioned and it has not appeared, it will appear if it has been accepted. If it has not been accepted, please wait for 1 week. Yes. লিস্টে দিয়ে দেবেন লিস্টে দেবেন না
Lordship, let me mention one matter of operation. Matter only I filed a appeal under 107 was taken on the grounds of delay only, madam. Now recovery notice has been issued.
Please wait for a week.
Lordship, may I be permitted for the upgradation? I have also filed the writ petition, but in the meantime, they have recovered the 24 lakh rupees.
Please wait for a week. Next week, please mention next week. Call করুন list call করুন.
Item number 1.
My lord, I'm appearing for the petitioner in item number 1.
Why is it appearing under the hearing to be mentioned?
My lord.
Why to be mentioned?
My lord, this is the CAN application that I'm moving. Your petitioner is praying for a leave to avail the benefits under
Want to
the.
withdraw the writ petition.
It may be disposed, my lord, in terms of.
Can't be disposed. It has to be withdrawn. That
My
is
lord,
the scheme.
My lord, leave may be granted and the matter may be withdrawn.
But your prayer is not for withdrawal.
My lord, the CAN application is for the leave.
What is the scheme? The scheme says that you have to withdraw, isn't it?
My lord.
You have the scheme.
My lord,
Your
am
CAN
not
application is
carrying
very
the act,
fancy.
but my lord, section 4, subsection A says
Where is that? Show me.
My lord, the act I'm not carrying.
Because if you make a CAN, make prayers properly, this CAN shows that you should be allowed to file application under such and such. And there is no prayer for withdrawal of the writ petition.
My lord, this may be provided the act.
But there should be a prayer for withdrawal of the writ petition. That's not there in the CAN. देखियो नर्स स्कीमটা দেখি তুমি দা
My lord, once the leave is granted, I will make an application before the learned
First, you have
department.
to withdraw this writ petition. For that, you have to seek leave to withdraw the writ petition. That is not your prayer. That is the problem. If you had come up with an instruction, I would have allowed you to withdraw. But you have made a CAN application which is on record, which does not contain the prayer for withdrawal. How will I allow that?
My lord, prayer B covers everything, that any order may be passed.
That is omnibus. Prayer won't help. Withdrawal I'll allow under any order.
My lord, generally, once the leave is granted,
Generally,
disposing the
people
CAN
come and pray for
application.
withdrawal. That is generally. You have made a CAN, so you have to be particular in a prayer. Which rule 4A?
My lord, Group 4A. This is a matter regarding dispute under West Bengal VAT Act.
You file a supplementary affidavit. I'll allow it. This CAN has created this difficulty. I'm making it not today. File a supplementary affidavit. Take instructions. I mean, take help of your learned seniors. They'll help you out how to do it. If you file CAN, make proper prayers. Making it not today, come tomorrow.
My lord.
Yes. Yes, it's dicey. It's not that easy. A simple prayer for withdrawal would have helped. But yes, that would have been easier. Yes.
May it please, Your Lordship. Well, I'm appearing for the petitioner, my lord. If Your Lordship kindly takes up page 28, the assessment here is 1415, my lord. It's a covered matter. I'll quickly indicate.
No, but what happened in that Rajiv Bansal's case, that judgment I would need to see.
My lord, the Aarti marketing is not
Arkiti
in
marketing is not final. Arkiti marketing
Right,
was
right.
modified by Rajiv Bansal.
Lordship. Rajiv
What has
Bansal, my lord,
happened in Rajiv Bansal?
my lord, the TOLA, my lord, has been upheld in paragraph 114 of Rajiv Bansal.
Where is that?
114H, my lord, may I hand over? Rajiv Bansal, we have soft copies. The other judgments we're carrying hard copies, my lord. May I hand over, my lord?
Bansal is the only judgment of which you should have had hard copies.
My lord, I'm sorry. My lord,
We will let him come back.
yes, my lord. We have given the copies, my lord, to my learned senior friend.
Not
We'll
today,
come
today.
back. My lord, may it retain this position in the list, my lord?
Yes, it will
I'm
retain.
very deeply obliged, my lord, very deeply obliged.
এটা বুধবার দিন করে দেবে।
My lord, may I have your lordship's indulgence? Item number 1, lordship has marked it not today. Probably lordship wants a clarification which I can give you, lordship.
No, in view of the CAN, your oral clarification will not help.
No, my lord,
If
it's
you have
not
made
the
a
CAN.
prayer in the
It's not the CAN. What I wanted to submit, my lord, very humbly, my lord, under the Settlement of Disputes Act, it has been stated that a leave has to be taken from the Honorable Court if the matter is pending there, and thereafter, once the leave is given, my settlement will be.
You are not required to withdraw the writ petition.
No.
The writ
Once,
petition will also
yes, it will. The writ will stay pending. Once I get the settlement certificate, I will show your lordship in that terms. Then only.
Show me the scheme.
Yes. So writ একটা দাও। Print out আনা উচিত ছিল কি?
This is not going to help. This
Yes.
is very difficult.
No, actually, my lord, it is not a scheme. It is an act that
Whatever
is.
it is. it's
Yes.
Show me that.
My lord, passed over. It may be passed over. I will get that.
Next, not today.
My
Next.
lord.
My lord, Mr. Mansrai Chandan is appearing virtually for the petitioners.
Lordships, I appear in this matter, my lords.
My lord, I am appearing on Union of India, my lord.
Lordship, this is a case of IGST paid on exports, my lord. In this case, my lords, the refund has been granted. However, it is pending processing. The respondent number 3 has written to respondent number 4 on various occasions seeking to process it, my lords. In fact, my learned friend has made a statement before the court seeking instructions in this matter on the previous occasions, my lord. If my lords can turn their kind attention to page 73 for a minute. Kindly have page 73.
Please wait, please wait.
My apologies.
Instruction regarding this because the systems, it is the DG systems, New Delhi, which maintains it. So we are yet to receive the concrete instruction regarding this. And they have also sent, the department has also sent that the instruction that we have shot for is pending at their end. So if you also kindly grant us some more time so that we can come back with the proper instruction, the concrete instruction.
How much more time? May 2025.
Yes, my lord.
May, it's almost 1 year now.
At least 2 weeks time, lordship, kindly grant us.
Please do it within 2 weeks. It's unnecessarily pending. Likhene. Mr. De, learned advocate appearing for the customs authorities, comma, seeks some more time to take appropriate instructions in the matter, full stop. He requests for 2 weeks' adjournment, full stop, as prayed for, comma, lists this matter once again on February 17, 2026, 17th February.
But maybe on 18th, my lord. On 18th.
2 weeks will be on 16th. So I
Well,
have some possibility that yes.
My lords, 18th I'm in difficulty, my lords. My apologies, my lord. My since 17th, my lords, I'll be there, my lords. My apologies, my lord.
You want on 17th?
Yes, my lord. Please, my lords.
Want on 17th.
My
Your
apologies.
other friend is on difficulty on 17th.
On any day,
Lordships may keep it on 19th then, my lords, if my lords.
19th will be difficult because 19th will be unauthorized occupancy.
Lordship, then let it be on 17th, my lord.
No use, he will not be there. We'll have to again adjourn it.
Lordship may keep it on 24th then. That's not 2 weeks, but then subject to lordships, subject to lordship.
24th, February 24th, 2026. Yes.
My lord, my name be kindly recorded for Union of India, my lord.
Please give your name in the chat box. It will be
All right, I'm grateful, my lord.
Obliged, my lords.
Thank you. Next.
My lord, here, my lord, against the appellate order, I am ready to pay 10% for ABDV, exchange of ABDV. Appellate order at page 134, my lord.
Kenin. This writ petition has been filed
The last occasion, your lordship, Mr. Tanay Chakraborty had sorted.
Lordship, the subject to correction, the main issue was that
You have got your instructions. You wanted
Lordship,
time
I
to
have
take
got the
instructions.
instructions, but the main issue was that in show cause notice, something was in show cause notice in adjudication order, something was there which was not there, subject to correction, which was not there in the show cause notice, your lordship. But if I may briefly try to explain this thing. What happened, your lordship? Your lordship kindly sees the show cause adjudication order.
Page?
It starts from your lordship 49.
Page 49.
Yes. And the relevant portion will be page 59. If your lordship kindly comes to page 59. Second paragraph.
Page 59.
Lordship.
Yes.
Second paragraph, upon analyzing and verifying the e-way bills submitted through Vahan portal of the details of the vehicles have been generated and some suspicious observation regarding vehicles paying capacity has been made by the undersigned. Hence, the owner of the vehicles was summoned to verify the details provided by the RTP. In response to the summon issued, the vehicle owners appeared before the undersigned and in some cases summons were non-communicated. Declarations given by the vehicle owners who appeared in compliance with the summon are discussed below. The owners of the vehicle, so this is your lordship, yes. What my learned friend is saying, that vehicle owners at the show cause stage, they were never asked to come. They were never verified or anything, verification or anything has not been subject to correction. That has not been done. But in the adjudication stage, how you are doing this? It is exceeding the scope. If your lordship kindly comes to section, because section 75(7). Because it draws the contours of what can be done and what cannot be done regarding amount of tax, interest and penalty demanded in the order shall not be in excess of the amount specified in the notice, and no demand shall be confirmed on the grounds other than the grounds specified in the notice. So there are two parts. Amount has not been changed. In the show cause notice, whatever amount was there, it is exactly there. There is no new ground because this is a part of an investigation. They had submitted certain e-way bills. To verify those e-way bills, I had started verification.
No, this ground was there in the show cause
They
notice.
had submitted the e-way bills.
They might have submitted. Was this ground there in the show cause notice?
This is not a separate ground in itself, your lordship. The definition of ground should be there. Various allegations which we see.
Yes. So this is also an allegation.
This is also an allegation, your lordship, because they are saying.
Very well. So this allegation should also be there, that upon verification of the e-way bills, it is found that you have done certain suspicious
This ground was
transactions.
existed because when they have
Show me
submitted,
that ground that
your
it
lordship,
existed.
show cause notice. Because e-way bills details, it has been observed, if your lordship 217,
which
starts from page, show cause notice starts from page 211.
211.
Page 217. Page 2, the allegation is 216.
16. Yes.
Regarding 1, 2, 4. This ground is regarding ITC uploaded by suppliers whose registration has been cancelled retrospectively. Cancellation. It appears from the. So this is the ground that ITC, that supplier was not. So there has to be some kind of vehicular movements. And in 217, paragraph 4, if your lordship, e-way bill details, it has also been observed that there is only.
Where are you reading?
Page 217, your lordship. It starts, the ground starts from 216. Following points have been observed.
Yes.
It appears that from the available records that RTP has claimed CGST input tax credit to the tune of so and so and SGST so and so. But Matashri Snacks Limited has received his registration by means of fraud, willful statement so and so. No further action has been taken. Again, in instead, RTP sold goods to Stuti Enterprises. The two companies have outward supplied to Vatsal Packaging. Here it is to mention situated. So the allegation has been raised regarding that the fake suppliers. After that, from e-way bill details, it has been observed that there is only one HSN goods, and all the movements have taken place without changing the nature of the goods. Hence, prima facie.
Where are you reading again?
Paragraph 4, Your Lordship, page 270.
Paragraph 4, yes.
Hence, prima facie, it transpired that the invoices and the e-way bills have been generated without any movement of actual goods in order to enable the buyer to avail ITC. So these are the allegations which has been leveled, Your Lordship. After that, he has submitted certain documents, verifying those documents, Your Lordship, that whether the transactions have been genuine or not. Because after in paragraph 5 also, the RTP, there's this e-way bill, regarding this e-way bill, it's there. But until and unless I verify those e-way bills, verify that whether there is actual any transaction or not, that cannot be considered as a new ground, Your Lordship. As per my limited understanding, that is a part of the chain which has been established in the show cause notice in the adjudication order, that to link whether there is actual any movement of the goods, that during the verification, this all new things came up. So it cannot be considered as a new ground, Your Lordship.
And these vehicle owners whose statements you have relied on, these were all supplied to them at the time of
Vehicle owner
show cause.
Show cause notice, no, Your Lordship, because later on it has been done.
No, but then that creates a new ground, isn't it? Whether they are right or wrong, whether this has been rightly stated by them or not.
He should be given an opportunity to counter that. That I humbly agree.
That itself makes a new ground of it.
But that can be very well staged before, because one forum is still.
I understand culling out certain things from the documents which he already had notice of or which he had opportunity to deal with. Now, what is a ground? A ground may not be something which is merely an allegation. A ground is something on which you sustain your ultimate conclusion. The ultimate conclusion is sustained on something which was never made across to them.
But Your Lordship, one forum is still left.
That's right. But then
appellate authority is still left.
That's right.
They
But
can
then,
very well.
But then section 75(5)(7) is for you. Is for the proper officer. Section 75(7) is for the proper officer.
Proper officer, that no demand shall be confirmed on the grounds other than the grounds specified in the notice.
So this is a facet of violation of principles of natural justice when you condemn a person without hearing him on a ground which he is supposed to answer.
Lordship, then I may rely on Allahabad High Court judgment, Mayank Minerals. Because we have given this judgment earlier occasion.
Lordship, may I humbly submit?
Let him complete first, then I shall come to you.
Mayank Minerals. Lordship, if I may hand over a copy after reading. Lordship, in this matter, paragraph 13, 14, and 15. I apologize, Your Lordship.
No, not.
सब केस खत्म हो जाएगा तब देंगे, तो क्या हम उसको एकेडमिक पढ़ाई करें घर में जाके? तो हम लोग सब जजमेंट आप लोग को दे दें। आप लोगों ने बोला क्वेश्चन करवा देंगे, अभी आर्ग्यू करेंगे, मैं जजमेंट तो दीजिए। बाहर कुछ और बोले।
Yes, but this was where specific points were raised, and the question was only as regards quantification. In that context, the Allahabad High Court has held this. But here the specific point is not there.
But quantification,
subject to hearing them, of course.
But quantification doesn't change, and these two grounds, Lordship, the only trouble is that whether it constitutes a new ground or it's a continuation of a new ground. Right? I apologize, Your Lordship, I have not.
No, not at all. Please. Yes, sir.
Your Lordship,
Why should it not be held to be a continuation of the new ground?
Your Lordship, because
of the earlier ground.
Before the issuance of show cause notice, Your Lordship, they had issued me a pre-show cause notice. I had submitted the same exact documents which I have submitted in my show cause notice itself. Had it been the case that it was the first time that I'm submitting these documents, then they are bringing this in order, it would have been a different case, Your Lordship. But this is not the case. In the stage of pre-show cause notice itself, I have submitted the relevant documents, and on basis of that, they have not even considered my reply to the pre-show cause notice. They consider my reply to the show cause notice, and then they give this additional ground, Your Lordship. If Your Lordship will kindly produce my reply to the pre-show cause notice, Your Lordship.
Page?
The detailed reply starts, Your Lordship, from page 85 onwards. Your Lordship will come to page number 88, Your Lordship.
88.
In this, my reply to the pre-show cause, Your Lordship, I've already enclosed documents such as bank recovery documents of the supplier, purchase bill, recipient copy with the e-way bill, payment details, GSTR 3B of the supplier. Your Lordship will also find it, Your Lordship, it is on page number 97, Your Lordship, I'd submitted the invoices as well as the e-way bill, Your Lordship. Page 98, Your Lordship will see the e-way bill is coming.
Yes.
So, had it been the case, Your Lordship, that it was only during the show cause noted that had participated in the adjudication proceedings, and on the basis of that, they have given an additional ground, even then it would be barred by 70.
His argument is different. His argument is, if you come to page 217, which is your show cause notice. Got it? Page 217, ground number 4. Mr. Sanyal?
Yes, sir.
4. Now, his argument is that this ground encapsulates within itself the ground which has been mentioned at page 59. Rather, page 59 is a detailing or an elaboration of what is already there in ground 4. That is one way to look at it. He cannot be said to be absolutely wrong in what he is saying. How do you deal with that? How do you respond to it?
Well, may I submit? Reading the
Why is he not submitting? Let him submit. Yes. Yes, feel free.
Your Lordship,
I am equally at par with you. With GST laws, even any law, but yes.
Your Lordship, my humble submission would be, Your Lordship. It is a settled position, Your Lordship. If any relied upon document or a statement is being relied upon by the adjudicating authority at the level of adjudication, then the copies of which it compulsorily has to be supplied to me, Your Lordship.
Where
Otherwise,
is that case made out? Where is that case made out? That was a query of court. Where is your case to that effect?
Your Lordship, I would have, because in the order itself, I have received these documents for the very first time. Had it been the case, I received it during, and they have not even given me the details of the either the relied upon statement or then
No,
opportunity.
that case has been made out in the writ petition.
Yes, Your Lordship.
So
We'll see the grounds, Your Lordship.
Page 27, if I'm not sure. I cannot improve the second try, but
Page 27
on the ground. See. But again, they are saying two additional grounds.
Well, they should be confronted with that because they don't have a chance.
To confront.
Yes.
That
So
is that.
they don't have a chance. You rely on somebody's statement and then strike out their defense. That's not done. Give them an opportunity, hear them.
Kindly reverts back to the authority.
That is what
and no limitation.
Yes, yes.
Your Lordship, may I humbly submit one thing, Your Lordship. Your Lordship, they have relied upon the statement of the transporter, Your Lordship. Be telling you, Lordship, as to the
no merits adjudication here. You go back before the appellate authority, thrash it out there.
My lord, that is not what is submitting. All that we are submitting, my lord, that they have taken statement. My lord, these are all roadside transporter. They are not transport company.
You say that to them.
No, my lord, I just want to point out what, my lord, the remand back with, my lord, just observation, my lord, of the cross examination of the relevant persons.
You ask for that. That has not even been.
My lord,
I will not allow everything here. You go and ask, let something be done there also.
Just 1 minute. I will take only 1 minute. They have, these are all roadside transporter. They transport locally. They are not transport companies. So the owner, they have invited owner to give a statement. Owner is not aware to whom the vehicle is given. The driver are there and there are brokers who engages them, and it is the driver and the broker who are, my lord, involved in the process of engaging that particular truck through which the transport. So they have taken, if they take a statement of somebody who is not involved.
You challenge that. Whenever it is put to you, you challenge it in the manner known to law. I cannot sitting here. I will not do everything.
All that I'm submitting, my lord, that we should be given cross examination of everybody.
You ask for it first.
They have to ask
Let the statements be produced before you. You ask for it.
Because the appellate authority, they have already missed the appellate authority. They could have very well gone before the appellate authority and asked for this.
Yes. This writ petition assails an order, an adjudication order dated
My lord, kindly
to support the ultimate
No, no, but
conclusion
kindly just give me 1 minute.
or reason.
Kindly just give me 1 minute. The basic premise on which they initiated the entire proceeding is that the supplier's registration is cancelled retrospectively. That is the premise on which they started. Now, the supplier's cancellation of registration with retrospective effect, that cannot be the reason to deny me the benefit of ITC. There are a number of judgments of this Honorable High Court. Now, there is a judgment of the Supreme Court also in Santi Kiran in the context of VAT law, but which equally applies to, my lord, this GST scenario also, whereby, my lord, they initiate the proceeding on the basis that the supplier's registration is now the supplier, my lord. He is a private limited company. They are having the several, my lord, we have annexed various documents to substantiate that they are very much in existence. They are setting their eye to that, and they are bringing new grounds in the
We are
order.
taking time. So Dharunto, I'll go through these papers tomorrow. Let it appear tomorrow. Kalke rekhe din. Third learned advocates appearing for the respective parties. List this matter for further consideration tomorrow. I'll go through this. It is seemingly not that easy.
My lord, I'll just point out.
Specifically, it says that there is no movement of the goods. Based on that, because their DRCO 6 is very extensive.
No, my lord, I will show, my lord, on so
Tomorrow.
No, my lord, just, my lord, allow me.
No, tomorrow. Next. I have gone through it. Now it's my education now to be done. Yes. Pass over. Next.
May it please, my lord. My lord, this is that matter with regard to cancellation of registration. My lord had directed me to come up with a CGST.
Yes, Mr. Rai was directed to take instructions. Where is he?
I do not know, my lord.
Passing it over, bring him. Mr. Bhonjo? Where is Mr. Rai? He was there on the last occasion. Making it not today, inform him. Next.
I appear for the press.
Lordship, I had challenged a show cause notice invoking section 74, and during the pendency of the writ petition, department has passed an order for which a can is also on record, Lordships, bringing the order on record. Lordship, on March 3rd of March 2022.
Did it? Located in. Okay. Yes.
Lordship, on 3rd of March 2022, I received a letter from the anti-evasion wing requesting certain details. I replied to that and I sought certain time, and I replied also that I have not done any transaction with this particular supplier. It was for one supplier. Now, Lordship, again on 27th February 23, 1 year later, anti-evasion again issues a summons. I again participate, I submit another reply. Then June 23, anti-evasion again gives me a letter. I again reply to the same on 6/11/23. This continues. From 2022 March it started. In the meantime, in August 23, I receive a notice for conducting audit by my audit commissioner under section 65 for 5 years. I write to the audit commissioner that anti-evasion is already looking after these affairs for this period. So I will submit the document for balance period. And in midst for 2 years, 18, 19 and 19-20, I received a show cause notice under section 16(4) by my proper officer, my judicial officer under 73, which I also replied, and because there was an amendment in 16(5), all those 2 cases were dropped in my favor. Now, Lordship, after all these exchanges of letters, summons, and submissions, on 11/6/25, after 3 years, anti-evasion issues me a show cause notice for the period 18/19 to 23/24, invoking suppression. They started the proceeding on March 22. It is not a case I have not participated. I have replied every time. Now, the show cause which they issue, Lordship, it has two parts. One, around 88 lakh, they say, ITC availed on certain dealers who have not filed 3B or whose RC is cancelled. I understand that, Lordships. But, Lordship, the major part of the demand is 1.48 crore is difference of 2A, 3B. And what they write, they give a table in the show cause. And they say, this 5 years, this is a difference in 2A, 3B, and therefore it is suppression. They issue me a show cause notice on 2A, 3B. 2A is a photopopulated data which is available at the portal at my end, at department end. 3B is which I have filed monthly. Just a table in the entire show cause and stating that this amount is recoverable under 74. So once that show cause came to be issued, notice, Lordships, I came before your lords challenging the show cause notice. And then they, in the meantime, they issued me hearing notices. I replied to them that the matter is pending. Those are also on records in the CAN application. But because the last opportunity was given, so we filed a reply sub judice to our players here to give them the justification why this is bad. In the meantime, they proceeded because they said the proceedings of 1819 was becoming time barred. They proceeded to pass the adjudication order without any discussions, confirming demand under 74 and invoking suppression at my end for 2A, 3B also. In fact, Lordship, 2A, 3B up to October 2019, the law was very different. It was 2A was always a self-assessment. The credit was to be availed on self-assessment without seeing 2A. From 1st January 22, the government introduced section 16 to AA, 16 to AB to mandate that any ITC which is not coming in 2B will not be allowed, just like TDS. If 26 years is not having that credit, I will not be allowed that credit of TDS. Similarly, the government came up with a mandate from 1st January 22. Prior to that, Lordships, October 2019, government came with a rule 36(4). They stated, okay, if your 2A is 100 rupees, you will allow you 120 rupees. 20% more you can take, subject to self-assessment. Then that 20% was reduced to 10%. Then that 10% was reduced to 5%. And from 1st January 22, because 2B came in, that was nullified. Now, when I filed my reply also, I showed them this comparison that see, whatever you are saying, I am well within my limits of 36(4) also. But Lordship, main question which I was, and what is my prayer before the Lord also is, for the same period, 2 years, already an show cause was issued to me, alleging disallowing my entire ITC on the grounds of 16(4). So they had verified my ITC that time also. Now, for the same period, and they started an investigation in 22. Now 25, when the June 25, because it was becoming time barred in June 30th, June 1819 would have become time barred. They issue me show cause on 11th of June, invoking suppression on 2A, 3B. And what they write, Lordship, I take your Lordship to the show cause notice. What is their allegation in the show cause? Well, Lordship, audit is also coming simultaneously. I write to audit, okay, this period I will not give you. So finally, in the show cause, they have written that they communicated with audit, and audit has stated what I have replied. This is also pending with anti-evasion. There cannot be multiple proceedings. Our division, my Lordship, in RP Buildcom has given a categorical finding that the person who starts, he will conclude. Multiple proceedings for the same self years cannot be done. The Lordship, 74. When can 74 be invoked in case of 2A, 3B? RC cancel, Lordship, I am again saying it's a matter of, it's a factual dispute. Department is saying these were not existent. I had submitted my invoices, e-way bills, all those records are there. I am not disputing you those things. But how can, and Lordship, kindly see, they came in 22. 25 June, they issue me show cause invoking suppression. At that time, the normal period of limitation up to 1920 was already over. And under 73, they had already issued me 2 show cause notices. So how can the charge of suppression against me, my lordship, kindly take the show cause at page number 76.
76.
Lordship, 76 is the DRC one summary. And Lordship, I am also on bunching. Though there is no prayer for bunching, I can file supplementary subject to your Lordship allows. But first I am on suppression. Bunching, I brought certain judgment, Lordship, subject to your Lordship allowing that then only. 76, the detailed show cause starts at 81.
Yes.
Lordship, I read the first two paragraphs that is to be. Lordship, first paragraph, where on the basis of facts, ground, prevailing legal provisions, it appears that messes this with effect from this, falling under jurisdiction this. The said RTP availed, last three lines, Lordships, availed and utilized inadmissible ITC amounting to 88 lakhs, either on strength of bogus invoice issued by non-existent entities without receiving the goods or services during 18-19 to 2021, or on the strength of invoices by the supplier who has failed to file their monthly returns. First allegation. Second, Lordships, and whereas it appears the state taxpayer have taken illegal excess ITC to the tune of 1.48 crores on account of excess ITC in 3B in comparison to ITC available in 2A for 18-19, 19-20 and 21-22. To 2021 they skipped till 23-24 in contravention of this, read with this. Whereas the RTP also willfully suppressed the facts. Now, what they say for 74, Lordships, kindly comes to first page 92. Up to 91, Lordship, they have discussed all the proceedings and the allegation of RC cancel. 92, first time they come with 2A, 3B issue. There are 2.21.
Ninety-two,
Lordship. Further, the system generated comparison sheet as available in the portal. It appears that said RTP availed excess ITC in comparison to ITC available. Period. CGST, SGST. Availment as per 2A of the taxpayer from the comparison sheet, the excess ITC is noticed as tabulated below. So this is their allegation for 2A, 3B. And then they give a master table for both the amounts, for the first and the second. Now, Lordship, 93. Reasons for invoking extended period. Lordship, may kindly come to para 3.6. 94. Further, as discussed in 2.21, Lordship, 2.21 was that table. That is the only allegation. 2.21 is that table I showed, the comparison. As discussed in 2.21, the excess irregular ITC availed to the tune of this without any proper tax invoice or debit note or such document is violation of 16.2. Clearly shows the intent to evade payment of tax. This is their allegation for 74. They give me a table and they write this is 74. But if 74 kindly takes the provision. I have extracted that at page 171 also.
yes.
So the 74, determination of tax pertaining to financial year up to 23-24, not paid, short paid, erroneously refunded or ITC wrongly availed or utilized by reason of fraud or willful misstatement or suppression of facts. But may kindly directly go to the explanation. Explanation 2, which has now come under 74A. It has been substituted from 74 to 74A, Lordships. The explanation, which defines suppression. Explanation 2. For the purpose of this act, the expression of suppression shall mean non-declaration of facts or information which a taxable person is required to declare in return, statement, report, or any other document furnished under this act or rules, or failure to furnish any information on being asked for in act. This is what suppression is. Lordship, 2A, 3B. 2A is an auto-populated statement, which based on my supplier's records. 3B is what I file on self-assessment under section 59. They give me a table in 2.21 and they write in the reason to invoke suppression ki because of this difference, there was an intent to evade duty. I am not arguing on RC cancelled because RC cancelled is a separate issue. But kindly sees my major demand, 88 lakhs is of RC cancelled. This demand is of 1.48 crores. And this for 1890, 1920, when already a show cause under 73 was issued by a proper officer under 16(4), saying that all my ITC is time barred. Now, how can anti-evasion come and say that, okay, you are suppressed this fact? What is the suppression I could have done for this table?
Yes, Mr. Bhattacharya.
My first point is that it is not maintained as such because he challenged the so-called, he participated in the adjudication process, filed the reply. Therefore, he considered the jurisdiction of the authority matter. Now he cannot challenge the by a supplementary evidence. There is no ground for a single whisper why the order is bad. Now, my lord, the so-called has culminating into the order origin. There is no ground. Can you see the can? There is no grounds made out in the application why the order will be challenged. There is no violation of principle of national justice. Proper remedy is to lie before the appellate authority, my lord. And what he is arguing before Lord, my lord, these are all, my lord. One thing is so-called notice issue for, my lord, 16.2. That is not the issue here. Why, my lord, court will interfere? I put this question to myself. There is no really, my lord, any violation of principle of national justice, my lord, threshold. And there is no jurisdictional error. Why not it could be interfere with this? These are all factual matters. He will have to particularly appeal if he is agreed. Now, there is no ground. Can you see, my lord? Can you see, my lord? Page 6, my lord. Can you see, my lord? Para 6 and 7. These are the two paragraphs my lord can say here.
But Mr. Bhattacharya, if the show cause notice itself is vulnerable, suppose if it is held that the show cause notice could not have been issued, how will you sustain the order? Show cause notice gives you the ultimate basis to pass the order. If that is struck off, can the order stand?
Can you appreciate, my lord? Filed the writ petition. There was no order of stay. Now, my lord, he participated once he had participated in the adjudication proceeding, my lord. So they just he has no room to say anything.
No. If the challenge to the show cause notice is pending, and he brings that order by way of a supplementary affidavit or by way of an application, and he challenges that order also on the same ground that the show cause notice challenge is already there. He has said that this may be treated as a part of the writ petition. That is this can. Yes, so if I have to challenge the order, I can always say that this order has been passed on the basis of a notice to show cause which could not have been issued. That itself will take care.
Well, the judicial issue, official issue the so-called notice proper, because there is no such.
No, but what is your answer to that? How will he understand as to what is his allegation? There is a chart given and it is said that there is a suppression. How do you know that?
Well, kindly page 45, kindly.
Page 45.
Can.
45 of can.
Kindly see the 4.1.
4.1.
I have gone through the so-called notice along with records of the case. Submission has been notified with the so-called notice. Rather, submission made during the hearing and all records in hand are by the case that now discuss the facts of the whole evidence are there. I place before me and the legal person have been I find so the restriction have been by the fingerprint file that here is changed from High Court to the no stay for the proceedings has been granted by the High Court. That's why the application is for adjudication. Then I find the demand constitutes two parts, namely excess availment and utilization of ITC to the tune of service based on current ITC defective from GST 28 and ITC availability from GST 2019, 21, and 4. Then number 2 is inadmissible ITC available and utilized to the tune of service on account of electricity calculation or registration of free supplies during the period 89 to 22. Silent point of the contents of the food put forth by the RTP in the demands above as under regarding the first issue, the RTP may contemplate that ability to view that inward supply from PSA 3 by the recipient is in the nature of taxpayer contribution only. Therefore, any demand of tax based on difference in ITC as per books of accounts, which has been duly available to PSA on same assessment basis, and that not reflecting in the PSA for the year 2019 case is not sustainable. And regarding the second issue, that in respect to ITC available on supplies from the suppliers whose registration has been cancelled retrospectively, the RTP contended that the mayor had GSTN of the vendor in consideration has been does not necessarily mean that ITC available all the transactions had taken place prior to the initial cancellation of registration, and they received the actual suppliers under payment made to the supplier. Here, the other part of the second issue, that the ITC on account of failure to file monthly form by some supplier, the RTP contended that the GST law as on date does not provide any mechanism to vouch whether the supplier has imposed the tax to the government. Moreover, really in conjunction with the version of section 41, it should impose any obligation on the recipient to filing of forms by the supplier. Therefore, the accused ITC and the recipient in, whereas the prohibition and the supplier in, on meticulous study of document submission. That's where my point-wise observations were 2.5.1 allowed issue of admissibility of ITC to the for services based on difference of ITC respective of PSA and ITC as a from
He has quoted this section.
Section then, my lord, kindly come, my lord. Page 47, my lord. As per the reply.
Yes.
As per the reply, the notice it appears that the notice may qualify the conditions stipulated in section 16(2)(a), B, and PA. But from the return filing status of the supplier of service or goods of the notice, it is clear that the condition prescribed in section 16(2)(c) is not satisfied. That is, liability to be paid to the government. Thus, payment is treated to be paid to the government only after concerned GSTR 3B filed with the registered taxpayer. In the present case, since GSTR 3B has not been filed with the supplier, as discussed above, it is implied the due tax liability has not been paid to the government. Hence,
No question, Mr. Bhattacharya, is how section 74. Section 74 can be pressed into service only if there is a willful misstatement, suppression, which has been defined in the statute. Otherwise, section 73. Section 74 gives you an expanded time period within which you can invoke. If you cannot do it under section 73 and it falls under section 74, a case which squarely falls under 73 only, can you bring it under the scope of 74 without stating anything? How will he know that there is a suppression? What is, as he says that 2A is auto-populated, he does not have any hands in that. 3B is self-assessment. Whatever he has done, now there is a mistake in something which is auto-populated, and there is a and his mismatch, sorry, not mistake, and his self-assessed return. Then how is it suppression? How do you drive home this point? If you do not put this across to the assessee, how will the or the registered taxpayer, how will the RTP answer to that? He has to answer to it. Where? How? In the show cause notice, it is precious little. At page 92, there is a chart given. And then page 93 is the reasons for invocation. This is the reason. Yes. But what is your answer to this, Mr. Kanodia? Page 93.
93, Lordship, which para, Lordship?
3.2.
3.2. As per section 38, every recipient
Come to fifth line. Thus the availment.
Thus the availment of IPC in excess of figures shown in 3B, 2A.
Thereafter.
2B, as the secretary has been provided, 2A, 3B, electronic, and the secretary was well informed with the quantum of IPC rightfully available. But with the malified intent to take the secretary has availed IPC in 3B in excess to 2A. Lordships, as per section 38 and has been held by the Honorable Supreme Court also, up to 1st January 22, 2A is just a tool. The law mandates to take ITC as per 2B from 1st January 22 onwards. Prior to that, it was self-assessment.
Where is that?
Lordship, Union of India, Bharti Airtel, Lordship. It is there in my.
If the law permits them to do that, that is why I asked him. Showing
Lordship,
the
may I kindly take rule section 16 once. I'll place the judgment also. Just kindly take the proof.
section 16.
16 once.
Section 16
to
AA.
AA.
Yes.
The details of invoice or debit note referred to in clause A has been furnished by the supplier in statement of outward supplies, and details has been communicated to recipient in the manner under 37. So this means, Lordship, that my supplier will file GSTR1 and it is communicated
outward supplies is
GSTR1. My supplier's outward supplies and communicated to me under GSTR2A. Lordship, kindly see when this was introduced, inserted by Finance Act 2021 with effect from 1/1/22 in the footnote. I'll show my book.
No, I've got it. With effect from 1/1/22.
Now, Lordship, again, kindly take 16 to BA now.
BA.
BA. The details of input tax credit in respect of supply communicated to the registered person under 38 has not been restricted. This is also from 1st of October 22. This was the second leg which the government brought. First they brought, okay, 2B is must. If it is not in 2B, I will not give you. And then they brought in, if it is in 2B also, but if it is restricted in the means 38(2) provides certain clauses. If my supplier's RC is cancelled, I will not get the credit. All these have come from 1st October 22. So
this
prior
could
to
not have been given
Lordship,
retrospective
so,
effect.
and the statute is very clear. Prior to this, it was Lordship, I kindly take my CAN application where I quoted the judgment of Bharti Airtel. I am handicapped with I have the soft copy. Lordship.
Yes, Mr. Bhattacharya, to this,
copy,
because this
Read C well.
the
Subject to the provision of section 41, the tax charged in respect of such supply has been actually paid to the government, either in cash or through utilization of input tax credit.
very well, actually paid or not. Question is not whether he is liable or not. The question is whether he is liable under 74 or not. That is the question. The question is whether he is liable under 70. We are absolutely on the point. Reasons for invoking extended period. Whether under this section he is liable or not. We are not on the liability per se. We are on the liability under section 74, because his jurisdiction is in question. He would have jurisdiction only if he can invoke section 74. He can invoke section 74 only if the section is applicable. The section seemingly is applicable from 2022. What will happen to those things which are prior to that? What is your answer to that? That is the question.
Just now, I can answer only. There are two issues. One is excess amendment, another is irregular inadmissible. Then irregular whose registration has been cancelled. That is my kind of 3.6.
That is another part. This major part is under section 74. Major part is 1 crore something which is under 74. No, if you don't have jurisdiction to decide one, merely because you have jurisdiction to decide one, you will impose penalty on the other also, or impose taxes on the other also.
That is what has been done in this case, Lordship. Exactly what has fallen for my lords. They have taken the shield of RC cancellation and just one para. Lordship, last 10 days up to.
Not for your because
very well, section 74 invocation is his main plank of argument. Section 74 invocation, you'll have to satisfy that yes, he had, because prima facie on the plain reading of the law, it is clear that this section came into effect, or the provision of section 16(2) AA. This came into effect from 1st of January 2022. Yes. All the years in respect of which you have invoked section 74 are prior to 2022. All of them are 18, 19, 19, 20, 2021. So therefore, how could this be invoked with back date? You have not invoked section 16(2)(c), Mr. Bhonjo. Section 16(2)(aa) says what you have invoked was not there in the provision.
section 16(2)(a), we have invoked. There one is 3.6. Then one is 16(2)(c) also, one is 3.6 kind is there. 16(2)(a), sir. Only A, man. 16(2)(a).
16(2)(aa) is a clarification. Why you can invoke has been clarified now. It was not there. Yes, it was not there. So when it was not there, then there were, now since it is there, there will be a question of suppression. You try to read it this way. Now section 16(2)(aa) is there. There is a particular provision and delineating the manner in which you are to act. You are not acting in that manner. You are suppressing something. Now something is absolutely wide open. You don't have any obligation. Whether you can be said to have suppressed. This is the question. Yes.
And so-called issues for the period, I think that was
All prior to 2022. Yes.
And they are the two issues.
It is not that you have invoked section 16(2)(aa). You are not required to invoke section 16(2)(aa). Section 16(2)(aa) sets the rule. It says that this is what is supposed to be done. If you do not do that, then that can become suppression. Whether before this being placed into the rule book, you could have alleged suppression in respect of, then what is the meaning of insertion of this? On what basis? That is
Lordship, that is my argument. And Lordship, because of RC and Lordship, all 2A, 3B state jurisdictions are also issuing. Every notice is under 73 because it is self-assessed data available in the portal. For 2A, 3B, only central GST invokes 74 without any mention of why. And Lordship, what my learned friend was reading, the allegation of 2A, 3B, he is bringing 16(2)(c), which was the allegation for RC consent. So he's jumbling up, the adjudicator is jumbling up just to protect. No. I can place Lordship that also on record.
Mr. Bhattacharya, you want to come back?
Lordship, till that time, the operation may be stayed.
When?
Only the limited. Till that time, Lordship, now order is passed. Lordship, may kindly see when the order was passed, Lordship. And I have filed a writ petition within time, Lordship. It is not that I have come to the court belatedly. Order was passed on 9th of December 25.
Only, as your Lordship, he has might be some reason given in the writ petition. When the canned application will end, is nothing, no, which part getting not in origin.
I brought that on record.
When can you come back?
Fourth, Lordship, I am not in Calcutta. Virtually, it will be difficult to address.
Then
10th, Lordship, 10th.
Let us have it on 10th.
10th.
1 week. 9th. 9th.
9th, I will appear in that.
11th.
11th.
11th. Till 11th, is there any requirement? 11th, I don't.
Lordship, let it, if on 11th something does not happen, then I will press. Lordship, in my can, I have given everything that I had asked for adjournment, citing this matter is pending, but because the
Mr. Bhattacharya, please see that nothing is done in the mean 9, 10, 9 days in between. We are on 2nd today. 9th day will be.
Any notice, without notice, they will not take any action. But any notice,
the officers will not take. Portal takes. That is our problem. Portal, if there is a balance in the credit ledger, if the balance is there in the credit ledger or cash ledger, it will be auto dated, not their officer.
Heard Mr. Kanodia, learned advocate appearing for the petitioner, and Mr. Bhattacharya, learned advocate appearing for the respondent CGST authorities. Mr. Chakravarti was supposed to be here, 11 and 12. Yes.
My lord, as I had already pleaded before earlier also, that no show cause notice or recovery notice was given to me prior to the recovery. As it was seen in the affidavit file also, the appeal has been disposed of with the department. But even after the appeal, no recovery notice has been sent to me. And the last recovery notice that was sent is in 2014, as stated in the affidavit.
Yes. 25. Yes. Page 3, paragraph 4.
Notice of hearing was issued to the petitioner's address or the same endorsement addressing whom was sent to them. After that, alternative there was an inquiry, and after that, alternative address was ascertained. It was the form was
Yes, they have issued notices to your alternative address. Recovery proceedings also.
My lord, yeah.
Where from where he had moved.
That is in the assessment order. After that, there was no intimation to the department if he has moved or not. So we had sent in the assessment order, he has filed, against the assessment order, he has filed and so notice of hearing of the appeal was issued to that address which was with the authority. So it has been, we are very well aware of what is.
My lords, but if my lord goes to para 6 of the same affidavit.
Para 6.
Yes, my lords. Immediately notice in form VAT CP1, wide office memo was dispatched by speed post to alternative address. As per the speed post tracking, the notice sent to the address of Santa Cruz duly delivered on 9/7/2024. So the alternative address was available with the department.
They
So
have given notice.
yes, my lords, but not after the appeal has been because the appeal has been disposed of in 2016 by their own admission. By their own admission, in the earlier affidavit filed, the appeal has been disposed in 2016.
Where in this case,
Yes, my lord.
where have they written that it is disposed of in 2016?
But in the earlier submission that was given.
No, this is the report in the form of affidavit. It should contain everything.
No, my lord, it's not mentioned here that the appeal has been disposed of, but it was submitted earlier. A date of March 16 was cited. And I believe my learned friend will also agree that the appeal has been disposed.
But
he has been given proper lordship's query on that whether.
no, but his submission is after disposal of the appeal. You ought to have given him another notice of initiation of recovery proceedings. Then also, even if he does not turn up, since recovery proceeding is another proceeding which you are initiating,
yes,
you should have put him on notice. That is what he requires.
After this is done by different authorities. Recovery authority is different. The authority which disposed of the appeal, they saw that the address has.
So when was the appeal disposed of? Where is that? He's saying that it was disposed of in 2016. Where do I get that?
It was submitted to the Lord.
How? Where? How? Why is it not part of the affidavit? Report in the form of affidavit should have contained, because this is the last document that you have. Then?
Unfortunately, the copy of that was not.
But appeal of appellate authority is ordered.
So why is it not part of the affidavit? It should have been there.
But as per my instruction is that ESCP 1 is the alternative address. Appellate authority has said And that notice, it says that the agency has.
I don't have any document which shows that the appeal was disposed of in 2016. How are you submitting that it was?
My lord,
handed up
it
to
was
court?
submitted by Mr. Chokro.
Must have been submitted, but there should
No,
be
not in the form of
something.
affidavit, my lord. That's the
Then
request.
that is what his court is to
Yes.
be relying on.
So I think
What is the use of a report if you have a report and then you rely on something which is not in the report? The report filed in the form of the affidavit does not indicate. Let such report be filed within a week from date. List this matter on certainly something in the affidavit, something orally, no, not possible. 11th February 2026. And please also indicate when the recovery notices were issued, if at all issued, after the disposal of the appeal. That is his contention. He says the recovery proceedings were initiated prior to the appeal being disposed of. In the meantime, nothing happened. Once the appeal is disposed of, he is required to be given one more notice. So therefore, what happened after that? Then how would you proceed with the recovery proceedings without issuing notice fresh? If there is a lull of 2 years, as you said in January 2016, if it is dismissed, then in that case, from 2014 to 2016, there was no recovery. From 20, very well, 2014 it was issued, 2016 his appeal to the assessment order is dismissed. From 2014 to 16, there is no recovery proceeding. Whatever might have been the reason, after 2016, you again assume jurisdiction to recover because the appeal is gone. That all of that should have been there. What was the use of calling for the report? The report is perfunctory then. It's we are again back to square one, despite the report being there on record. Notices which serve any purpose, Mr. Sanyal. You show me a notice which he will immediately knock the bottom off. What is the use?
Then I'll bring the entire, whatever.
Yeah, you bring a comprehensive report. Report is for that only. Otherwise, what is the use of calling for reports then? That is all good, but whatever you have, that also has not been mentioned. It is coming in piecemeal now that appeal was disposed of. All of this should have been there. If it was there, I would have disposed of the matter today itself. Unnecessarily time goes. Next. Same order.
no, my lord, it's about CST, but can we have it after the break?
Yeah, in this, there is some. While learned friend has mentioned the appellate authority's order, he has annexed the petition.
Yes.
It is not the same.
Page. I'll come back in 5 minutes.
Yes.
Yes.
Well, this matter, in this central matter, there is the recovery notice has been sent on the same date as was sent in the earlier date. But the recovery that has been attached, the recovery notice that has been attached to the affidavit, that the amount is not matching to the amount of the Aspen proceedings. Well, the assessment order is given on page 27A of the petition.
Mr. Dasgupta, what would be your defense now? Recovery proceedings they can initiate.
Yes, my lord.
It's not time barred. What will be your defense
My
unless
lord,
you pay?
this is, I have an authority from the Honorable Supreme Court, which says even the administrative decisions, they have to be done within a reasonable period. If the
This is on reopening. This is not reopening. This
no,
is
my lord,
sub-
this is about the time limit, where there is no time limit or limitation for an administrative decision, whether a reasonable period has to be followed.
Then
But
we
before
can-
that, my lord, I'll take my lord to page 27A.
27A.
My lord, the total amount demanded is 4,12,099.
Yes.
But in the recovery notice, which is in R3 of the affidavit filed by the revenue, on page 7, my lord,
Yes.
the tax amount is 15,17,500.
And where is the assessment order?
My lord, it's on page 27, and the type portion is in 27A.
Four lakh 12,000.
Yes, my lord. But the recovery notice,
Sanyal, how is this that the recovery amount is more than the assessed sum? Yes. Sure.
no, my lord, we are talking about the assessment order first. Assessment order, page 27A of my petition.
9 to 10. 9 to 10. Period appears to be the same.
Yes.
Pay.
No, even if you take your R2 and R3, if my lord takes R2 and R3 of the affidavit only, there is a difference. R2 versus R3. In R2 also the same figure, 3,09,849 tax, interest of 1,64,220, which is the assessment order as per the revenue. But the recovery notice is sent for 15,17,500. Hey, R2 or R3 और R2 तो देखो डिमांड ये आगे पता है tax amount is 309,849.
Mr. Sanyal, please clarify the stake instructions on this. How is it differing?
And my lord, I would like to argue on this on the next day, my lord.
As requested by Mr. Sanyal, list this matter on 11th.
Yes, my lord.
On February 11th, 2026, to enable Mr. Sanyal to take instructions. Next.
Obliged.
Yes.
My lord, kindly allow me a couple of minutes so that I may recapitulate. This matter is under Service Tax Act, and the fundamental challenges are to the jurisdiction. And jurisdiction are at least three. One is the territorial jurisdiction, which they lack, because I am not within the area where my assessment has been made. Second is jurisdiction of the superintendent to pass an order against me by invoking extended period, which has been prohibited under the circular of the CBEC. And third is that the show cause notice that has been issued to me by invoking extended period of extended period does not indicate any justification or reason for doing so. It is bald allegation, just quoting
Proposed notice is without particulars.
without any which I could have answered if given to me. So these fundamental challenges, if I succeed on any of these, the notices will go, jurisdiction will go, everything will go. My learned friend has been trying to answer one of them. Then I have supplied all the papers about them. So it is now his turn to satisfy the court. What has
Yes, Mr.
to say.
Bhattacharya. Serious point is jurisdiction, subject matter.
No, even territorial, my lord.
Notification 2 have been handed up. Which one? Yes.
Adjudication of confiscation and penalty by intellectual absence provided power under
Which portion are you reading?
Which circular?
Serial number 2, yes. Yes.
Demanding duties not paid or not paid. And the power power
দিদিকে একটু ডাকো একটু বের করে দিলাম সব একসঙ্গে গেঁথে দিলে আমার অসুবিধা হবে ইয়েস
My lord.
Yes.
Petition की copy with the
extended period of repetition can be kept out of the party of the administration.
So short paid, not paid is within the period within the jurisdiction of this superintendent unless it exceeds 10 lakh. And if it exceeds 10 lakh, the short paid, not paid also goes out of the jurisdiction. And so far as these three are concerned, taxability, classification, valuation, extended period of limitation, these four issues, even if it is within 10 lakhs, it is beyond the jurisdiction of the superintendent. Yes, now he's absolutely right. That was my reading also. Mr. Khan says that this case involves extended period of limitation.
It is apparent.
So if it is extended period of limitation, then it does not have jurisdiction.
So let it be.
Yes.
Then nothing
I'm
remains.
going on this only.
There's nothing remains if it goes on this ground.
This writ petition. That is the notification. Let us see the status. अपने यहाँ से करें. बोले यार. Let him show. That is why I'm keeping at 2 p.m. Yes.
Fourteen melodyne for the petition.
Yes. For what?
For being late.
No, no, you were there in other courts. Not a problem.
My lord, this is the matter, my lord, relating to refund. And my lord, on the last occasion when the matter was taken up, my lord, I had raised an issue about section 54
Yes.
of the act, my lord, and the use of
What
the word
was the
may
issue?
there.
Section 54 is directory.
Mandatory or
Mandatory or direct?
Yes.
And my lord, and what has fallen from my lord is that if there are precedents, then my lord will follow, and if there are no precedents, then my lord will interpret. That has fallen from me. Now, my lord, there is a judgment which I have relied upon. My lord, I am providing a. Yes, my lord.
There are two judgments which are in his favor. There are 4 judgments which is in my favor. So now there is a conflict of opinion. Lenovo in the first time said it is not mandatory. But my reading of it, whether if someone says, can we consider this aspect? I would like to ask this.
What is section 54? Let me see that first.
Specifically, my lord, section 54(1), my lord, if I may place.
Yes.
My lord, any person claiming refund of any tax and interest, if any, paid on such tax or any other amount paid by him, may make an application before expiry of 2 years from the relevant date in such form and manner as may be prescribed.
Suppose we read it as directory. Then will that mean that you can come up at any point of time after 10 years?
Yes, my lord. This is the conflict, my lord, and if I may submit,
then it has to be given a reasonable meaning.
Yes, my lord.
The limit can be made by judgment. So like a legal picture, that cannot be created.
My lord, may I just read into Lenovo, my lord, the judgment that I am relying on, and the judgment which basically gives the interpretation that
Lenovo.
it is directory.
Yes, yes, there.
My lord, paragraph 15.7 to be precise.
15.7.
That, my lord, is at page 38.
15.7.
My lord, I am reading it. Thus, a reading of section 54(1) of PGST Act would make it clear that the SSC can make an application within 2 years. The terms used in the said section may make application before 2 years from the relevant date in such form and manner as may be prescribed, which means that the SSC may make an application within 2 years, and it is not mandatory that the application has to be made within 2 years. And in appropriate cases, my lord, this has to be read into, my lord. In appropriate cases, refund application can be made even beyond 2 years. My lord,
So this judgment is in a sense giving discretion to the officer concerned to entertain applications even beyond 2 years.
Yes, my lord.
So
that would have been my submission today, my lord. That in appropriate cases where the parties have shown diligence, my lord, basically the object of imposing a limitation in a particular statute is to ensure diligence. Now, if the party has been diligent, my lord, in that case, he has to be given that benefit, my lord. In appropriate cases, even, my lord, I have brought another judgment, my lord, which is against me. My lord, may I?
This Lenovo was cited by you.
Yes,
and Mr. Chakraborty has cited 3 judgments. Cherish.
My lord, here
Cherish is in your favor.
My lord, this judgment I have just
Entrance, yes.
submitted, my lord, Sethi and Sons, paragraph 26, my lord.
26.
Yes. My lord, this. আমি দিয়ে দিচ্ছি, আমি এটা করব।
26.
Yes. My lord, this actually is against Lenovo, but I am submitting that this judgment has entertained a new point, which is bona fide attempt, my lord. My lord, paragraph 26 in MS Lenovo India Private Limited, the Joint Commissioner of GST Appeals, such and such, my lord, the learned single judge of Madras High Court has held that period of 2 years as stipulated in section 54(1) CGST Act is directory and not mandatory. Thus, even if an application is made beyond the period of 2 years, the taxpayer's claims cannot be denied. We respectfully have reservation regarding the view. However, we do accept that if taxpayer has made a bona fide attempt to make an application but was prevented.
What is your case?
My case is that I had made an application first. There were some defects there. I withdrew the application on the very same day. That was within the time period, my lord. Thereafter, my lord.
When you made the application, the time had gone.
Yes, my lord. The second application when I made, the time period was over. That is
why did you make the second application later? After the expiry?
My lord, because my lord, one of our directors, my lord, health deteriorated, and there were changes that were required to be made in PAN and bank details, my lord. That was the reason, my lord.
Okay.
So a bona fide attempt, if it is made, my lord, then also it can be considered, and this judgment considers that point, my lord. So, my lord, what my lord, the concern, what is the concern about of the learned senior counsel for the state, my lord? My lord, that is that if it is held to be directory, my lord, and if a blanket interpretation is given that the section is directory, then my lord, refund applications will come up 10 years down the line. But my lord, if the judgment of Lenovo is considered, my lord, in appropriate cases and where bona fide attempt is made, my lord, then my lord, the concern that is raised, my lord, is placated, my lord. That is the crux of my submission.
BLA infrastructure you had cited?
No, I had submitted.
You had.
That
it has given some additional reasons also. Paragraph 23.
That is my submission.
That is why I said it.
I should not say anything. Just refund by nature is not a constitutional.
No, it doesn't say that. Your constitutional right is to retain taxes that are payable in accordance with law, 265. So something which is not payable to you and something which is refunded.
Can you some observation? Paragraph 99. Yes, there got the citation for 99, 2022 to SCC 60.
99.
We must be cognizant of the fact no constitutional right is asserted to claimers as there cannot. Fund is a matter of statutory principle. Parliament was within its legislative authority in determining whether refund should be allowed of unutilized ITC tracing its origin both to input and input service, or as it has legislated input goods allowed. By its clear stipulation, the refund would be acceptable only where the unutilized ITC has accumulated on account of the rate of tax on input. being higher than the rate of tax on output supply, Parliament has confined the refund in a manner which we have described above. While recognizing an entitlement to refund, it is open to the legislature to define the circumstances in which a refund can be claimed. So that I'm taking inspiration from that.
This is one of the circumstances in which refund can be claimed.
But it is only restricted to 2 years. Today, my lord, appropriate cases, these are all, my lord, would be powers under Article 142 subject to correction. But this is not there in the legislation. This would be powers, my lord, beyond the scope. Appropriate cases, my lord, what would be the appropriate case? What a company coming up and saying that one of the directors is not well. It's a private limited company. It's not there saying the accountant who was considering or who was the authorized signatory was in. That is also my limit does not submit. But this cannot be an excuse, possibly I can excuse. But today, according to me, 2 years is very clear. But tax matter, the interpretation is always different. Subject to my limited knowledge, but a tax matter, the interpretation has to be as it is. We cannot put into words. So that today, what appropriate cases, these words necessarily we are putting words into the text. And the circumstances, that's why this 99 paragraph is very important. Something has been prescribed, we have to be followed to that. There cannot be any exception to that.
My lord, but at the end of the day, my lord, the legislature has used the word may, my lord.
May, my lord, can come to the section. May
When
on a different.
Yes.
Any person claiming refund of any tax and interest, if any, paid on such tax or any other amount paid by him, may make an application. May make an application for, but he can make an application. Show me there are other ways also. Make an application before the expiry of 2 years. In such form and manner as may be prescribed. Or not. Can come to 3. Subject to the provisions of subsection 10, a registered person may claim refund of any unutilized input tax credit at the end of the daily tax period. But all this gets upset. The pilot doesn't consider 2 years. So subject to the provisions of subsection 10, a registered person may claim refund of his unutilized input tax credit at the end of any tax period, provided that no refund of unutilized tax shall be allowed in cases other than that is the refund for the code. The application can be accompanied by 412. 5. If on receipt of such application, the proper officer is satisfied with the whole or part of the amount claimed is refundable, he may make an order accordingly. An amount to so determined shall be credited to the fund referred to as section. If pilot considers may, then passing an order also becomes.
Yes.
Now, when we consider, okay. First is the cherry sheet put under. And 7.
7.
Section 54(1) of the GST Act stipulates that the person who is entitled to refund of tax can make an application for refund of such tax within 2 years from the relevant date. 14, 54, 14, 2. 5, the relevant next week.
Hmm.
It says that the person who is entitled to refund of tax can make an application for refund of such tax within 6 years from the relevant date. The term relevant date was also defined in without section 54. The relevant date arises in the present, the date on which the vessel carrying granite block is exported from the. This is because the granite block is exported to us. The learned counsel has contained that section 54 stipulates the refund of a tax on granite was can be made as a interest in the 2-year period stipulated under section 61 of the section. 6 years from the end of the tax, the court is unable to accept. A cogent reading of section 61 and section 54 makes the scheme of that year. The right to claim refund under section 54 starts from the tax period starts from end of the tax period in which the refund arises. Under section 54, a dealer is entitled to claim refund of excess taxes within a period from the relevant date. It should be the outer limit. It is the outer within which the dealer is entitled to make a claim for refund. Well, outer limit is 2 years. Now, whatever the interpretation, if that means something is not in existence, is created. By judgment, that cannot. It's not a question of a reading out. Judgments cannot be read like a statute. Judgments cannot be read like a statute. And I can understand that provisions can be read down or read over, but both can be done. But the question is for an expiry of 2 years. It is not for an expiry of 2 years, the outer limit. So anything done by a would be by a legislating, which is cannot be the intention of a judgment, and which cannot be the judgment. So that is the second thing. But I'm not saying the powers are not there. I'm not saying, but
whether they can be exercised.
Now the Gujarat thing. Quotation of infection. 54, 16.
Yes.
Content reading of explanation 2 with section 54(1). It is clear that any person claiming refund of any tax and interest paid on such tax or any other amount paid by him has to make application before the expiry of the year from the relevant date. As per the explanation 2, relevant date means therefore, the fact of the case, the relevant date for the goods exported by the petitioner would be that from the date of shipping mentioned in the shipping. Therefore, period of 2 years is required to be calculated from the date of shipping. So the starting point is given, the expiry period is given. Both have been given by statute. From the paragraph 19. That's very important.
You have the judgment of Kirloskar Pneumatic Company.
But I had taken a print out of it. Time and I can come back tomorrow just to show 1 or 2 more judgments.
Not tomorrow. Tomorrow I've already fixed a lot of it. Kirloskar judgment, Kirloskar Pneumatic Company.
But I
What would happen then to cases, Mr. Chakraborty, if there is a technical glitch, the person fails, what will happen? How would you, if he does not have power, he will not have power at all. If he has power, why will he, how will you segregate the cases in which he can exercise power and which he cannot? If there is no legislative authority in him to extend. 54.5. Because if he has power, only then he will extend even in fit cases. Otherwise, if he doesn't have power, he doesn't have power at all. No, suppose the server was down because of the authority's fault, or because of no fault of his, no fault of the authorities, but the fault of somebody else. He was within time. How can you just shut him out? Because that is also substantive, something which is provided by the statute by way of a refund. He will not be entitled to it merely because then how would you here then you are actually reading may as shall.
So, I am saying may make an application. The stress is he can make an application. He make an application, may make an application before the expiry. The stress is have to be on the application, not for the expiry. The expiry has to be read as mandatory. Expiry is different.
You are relating may to his choice.
May make an application. So
He
the
may
man-
choose not to make an application and seek refund. That is what your submission is. But then suppose he exercises his right. He exercises he chooses to exercise his right within the time prescribed. He does that. He is prevented by factors which are extraneous and which is your own doing. Let me go to this extent, because we are testing the spirit of law now. Now, because of your own fault in the portal or whatever in the server, he is unable to upload the documents which are required. He is unable to make application. If the authority does not have power to extend, the authority will be powerless to extend even in such a situation. What was his fault then? What will happen? Every such matter will have to approach to the writ court.
My understanding.
Yes, 54.5.
54.5, he make an application. Now, madam, kindly come to rule 91.
Rule 19.
While the application
90. Rule 90. Yes, 90.
Whatever matter was void is covered by 3 provided. 90. While the any deficiency is the notice, the proper officer shall communicate the deficiency to the applicant in form DSP RFD03 to the common portal electronically. Requiring him to file a fresh refund application after distribution of subject. Provided that the time period from the date of filing the refund claim in form till the date of the communication of the deficiency by the proper officer shall be excluded from the period of 2 years as specified under subsection 1 of section 54 in respect of the fresh refund claim filed by the applicant after the notification of.
This simply talks about the deficiency memo.
But it talks about exclusion of that period also. Therefore,
Yes.
this indicates that this 2 years indicate a period of limitation.
But my lord, in my case, what has happened is I have myself noticed the deficiencies, and therefore I have myself withdrawn.
That is, you chosen a wrong time.
My lord, my lord, this shows my diligence, my lord. My lord, had I kept it pending, my lord, with those deficiencies, ultimately I would have been the beneficiary. Then such an interpretation would help those are not diligent, or there will be taxpayers who will just file it for the sake of filing, just to get that exemption, knowing fully well that the authority will give the deficiency memo and that period will be excluded.
I don't know whether it was not maintainable on that form. On minutes, it was not maintainable. It did not. This is something different. Well, here the legislature has protected the reasonable registered tax. And that exclusion, madam, that exclusion is a major. Someone comes up with 6 crore, that period has to be excluded in terms of fee provision. So, what appropriate cases has to be this, nothing beyond the statute or the rules. Nothing beyond the statute or rules. And once I can come back after seeing whether there has been any further development or not.
Come back when? Because this needs to be decided.
Yes, but this is an interesting one. But because when this further next 2 years become mandatory, or if this protection of 2 years becomes cautious basically.
Yes, Rule 19 has a bearing on the interpretation because a section may be explained by the rules also. It's a mandatory provision. Sorry, the parent provision. Rules cannot override the section, but they can always explain it in a sense as to how the legislature has thought about it.
It protects what has fallen from my lord, someone who has done it diligently.
No, but it is not taking into consideration that kind of a situation. That is still a question which will require to be answered because you are answering it in the interest of, because this provision is no doubt beneficial provision. It is beneficial for the taxpayers. They are entitled to get refund of the money which the law provides for. Now, the money is refundable to a person. He has made application within time. There is no defect. Suppose there is no defect. Let me go to that extent. There is no defect because of some problem in the portal. The form could not be uploaded on that day, and on the next day he gets the opportunity to upload it. He will be deprived of his right to get refund. What will happen in such a case? Whatever, Mr. Chakraborty, till the last day, he is within limitation. He is within limitation. You cannot attribute fault to him for waiting for 299 days if on the 300th day he had the same right which he would have had on the first day. So on the 300th day, if he has approached, and he has approached rightly, and he has failed in doing what he was supposed to do in terms of the statute, not because of his own fault, but a fault, say, attributable to you. What will happen in such cases if this statute is read so strictly so as to mean that you don't have power to extend at all? Difficult. When do you want?
That order automatically goes.
You have to challenge that. I cannot take into consideration something which is not before the writ court. Today it's only that.
Well, then, my lord, kindly keeps it tomorrow, my lord.
Tomorrow for what? I will not be able to take it up. There are other matters also. If there was an order passed against you, you ought to have challenged it, and that order is appealable. That is an appealable order. Why here? Merely because this is pending, you cannot club that to. Heard Mr. Next Monday, my Monday week.
Some issues has to be settled before it goes to the practice. I actually feel that way, but the difficulty is till 2023, before Lenovo, the law was well settled at this 2 years. Lenovo has altered the.
Upset it. Yes. Where? This week? Next week? No, I am not. Yes, no, thanks. No. There is a circular of 2017 which I found just now.
So like, we will be enlightened.
देखो तो दीदी दीदी नहीं है एक में खोल दीजिए उसको उठ दीजिए I don't know if there is any other circular after this or not. Both of you please see. This is against Mr. Khan and in favor of Mr. Bhattacharya.
Oh.
The flagged portion, flagged.
Flagged portion.
Authority to issue. Ideally, it should be issued by the same authority, but even if it is issued by the other authority, on that ground alone, it cannot be said.
One issue.
This is a master circular. Yes. This is the master circular. Please read it. So I'm leaving it at that, whatever it is.
Fine. So for now the adjudication order goes.
Order has gone, and the other points which you have raised as regards the jurisdiction of the
They
adjudication
remain
authority,
intact.
so far as territorial jurisdiction, I have not decided that.
And that not deciding will not be standing in my way for.
No, that is settled. That is settled. Mr. Bhattacharya also knows that.
No, but
That it has to be impliedly or expressly decided. If I would have rejected, if I would have not mentioned that line, then that would have meant that I have impliedly rejected your prayer. So I have said I have not decided, so no question of rejection comes.
That was the apprehension in my mind. What will happen?
If you see,
Res judicata.
of PPC, yes.
Explanation 5.
Explanation 4.
4 maybe.
That if it is not expressly, if it is not nothing stated, and it means impliedly denied. So I have expressly stated that I have not decided that. So it
Much
will
of
be a
that.
question.
Much of that.
You will ask this. I will clarify it appropriately. That it has not been decided, it is left open. এটা ওর ফাইলের ভেতরে রেখে দিন ওর ভেতরেই রেখে দিন The order remains the same. So the order impugned is set aside. Nothing about show cause. Ask him to come. If he's not there. He was there. Call him. Mr. Khan, he wants a line to be added that allegations are not admitted because affidavits were not invited. That I will record. लिखे नहीं, since no affidavits had been invited.
Had argued that when my appeal is time barred.
Oh, that matter.
Day after tomorrow.
Day after tomorrow. Day after. Day after tomorrow. दिए देंगे.
My lord, on the
I have seen so many. He has come up with intimidating collections. What is that?
my lord, my learned friend has already submitted a lot of
Authority. No. Lot of means what? 2, 3 years committed. What is the point? This is on what point?
My lords, 86A, whether blocking of electronic trade ledger can be done without traditional hearing.
Preceded by hearing or not?
Yes, ma'am.
How many judgment?
Yes, ma'am. But my lords, I have tried to counter the allegations that have been brought by my learned friend on, I'm sorry, the arguments that have been brought in favor of the revenue. So my lords, the first argument that was there is that 86A does not explicitly provide for a pre-decision hearing. So on that, my lords, as we were discussing last day, I've gone to the very origin of the judgment on principle of natural justice, Binapani De.
67.
Yes, my lord. 1967, yeah. So,
Sure.
So that is the first judgment that I would like to cite, my lord, where it says it is. But
if it is an emergent power, there is an opportunity of him giving an opportunity to him after the decision. That is what all the high courts are. So this is a post decision, there is an opportunity of specific post decision. But this is like an administrative order and implementing order. I take an administrative, the moment if I give a notice, my lord, the very purpose gets diluted.
No, the notice is not for the purpose of initial blocking. The notice is for the purpose of continuing the blocking upon the blocking being effected at the first instance.
Yes.
Initial, there has to be a notice.
Initial.
Yes, well, my lord, we have already cited the judgment of K9 Enterprises by Honorable Karnataka High Court.
Then the purpose will be frustrated. You may not have anything in your ledger by the time they go to block it.
But my lord,
it is like saying that you should have seizure upon notice.
No, my lord, I'll take my lord through page para 23, 24.
An element of surprise in this.
Yes, no, but my lord, I'll take my lords to para 23 and 24 of the Sahara India judgment of the Honorable Supreme Court.
Definitely there, that is a reasonable proposition that upon it being done,
yes, my lord,
you should be heard on the continuance as to whether it should be continued for 1 year or it can be done, because 1 year is the outer limit, after which you are bound to open it.
Yes, sir.
You are bound to lift that. Now, before lifting or before continuing it for 1 year, he cannot even continue for 1 day before informing you. That cannot be then the very purpose of the statute will stand frustrated.
But when
it has been done with a purpose.
Yes.
The purpose is that the revenue which is sought to have been in default or is found to have or is being investigated into, that should be secured.
Yes, sir.
To secure that, they have resorted to certain, they have indicated certain provisions which are, as Mr. Chakraborty says, interim in nature. interlocutory in nature. That's there. These are all temporary provisions, but whether they can be continued for a period as long as 1 year without giving you a hearing or not, that is a reasonable proposition. But at the threshold, you must be given a hearing even before blocking. That becomes very. Then in that case, there are several provisions. All of them will become OCS. For example, let us talk about suit.
Yes, madam.
That also has civil consequences. When an order of injunction is passed, an order of attachment is passed. At all times, the court is not powerless to issue an order of injunction or an order of attachment without putting you on notice. There are provisions to that effect that yes, after the order being passed, within a reasonable time, you have to be served with the order and you will have an opportunity to go and take your case before the court.
Yes, madam.
But that does not mean that the court will at the very threshold be excluded, because they are also revenue authorities. They have a duty cast on them to protect the revenue. So they cannot allow it to be absolutely evaded and then taken away. What will be left then?
But my lord, if I may take my lord to the judgment of K9 Enterprise and Sahara India also. In
For example, see, even in bank cases,
yes, my lord.
in SARFAESI matters, the injunction comes with the 13-2 notice. You are restrained from doing this. It's without hearing, because they have found an element of default. Ultimately, they may be proved wrong. It is not that all SARFAESI cases will end up in a recovery.
Right.
It may be found that the bank has committed mistakes somewhere and the entire SARFAESI proceeding is set at naught. But that does not mean that the power will not be there. We are at the question of power.
Yes,
at the threshold.
my lord, I'll take my lord through the judgment of K9 Enterprise. I will take my lord to the judgment of K9 Enterprise for Honorable Division Bench of Karnataka High Court. My lord, that's the first judgment that is there in the compilation.
Yes, K9.
My lord, in para 8.3.
8.3.
The first question that arises for consideration is as to whether the respondents are justified in not providing or granting a pre-decisional hearing before blocking the ECL.
8.3.
Yes, my lord.
8.3. Just yes.
The first question that arises for consideration is as to whether the respondents were justified in not providing or
How long
granting
will you take, Mr. Dasgupta? No, I'm not rushing you. Just to assess the situation today, because I'll cut you short at the moment and then we'll postpone it to the next day. If not,
Right, my lord.
today.
All right, I'll be grateful.
I will not continue with this whole matter.
No, my I'll try to take my notes. So, my lord, this was the primary question, that whether pre-decisional hearing before blocking the ECL and whether a positional hearing was sufficient in the facts of the case. So, here in para 8.12 of this particular judgment, my lord, the same has been answered in para 8.12.
8.1.
Yeah. Yes, my lord.
Para 8.12.
12.
Just a minute. 8.3, 8.12.
Yes, my lord.
Yes.
It is also significant to note that in the event the respondent revenue have not granted a pre-decisional hearing before blocking, the only consequence flowing from the same would be that there would be a possibility of appellants taking steps to utilizing or availing the ITC available in the ECL. However, the said process of the appellants utilizing availing is not instantaneous, immediate, unlike bank accounts, because it is with the revenue. I cannot, unless I report my outward supply, I file my 3P, I cannot utilize it. So for which money can, if the same are not attached and the same process culminating in the ITC being converted to actual benefit in favor of the appellants would consume time, as explained by the Gujarat High Court in Samay LS case Supra. So, my lords, the matter of that urgency, that with the urgency it has to be done, that is not coming in the matter of provisional blocking of credit, because the credit is lying with the state. It is not that it's like money that I can quickly withdraw my money from my account. I have to go through a set of process. And therefore, it says finally in the last lines that upon the respondent's revenue issuing appropriate notices to the appellants, providing pre-decisional hearing to invoke Rule 86A, the respondent revenue would be entitled to supervise, monitor the proceedings, including the ECL of the appellants, and if the circumstances so warrant, respondent's revenue would be entitled to block the ECL even before completion of the pre-decisional hearing was completed. So, my lord, this is one important factor that I would like to bring to the light, that pre-decisional hearing is a draconian right, is a draconian measure which has been taking away all my rights and it's bringing civil consequences. Why, my lords? Because as per the framework of GST as on date, If I don't file my GST at
Mr.
3B,
Dasgupta, now
yes,
here,
ma'am.
unlike bank accounts, I can understand. Say today I find that there is some sort of a problem and I should block it.
Yes, ma'am.
Today itself is the last date for you to avail input tax credit.
Yes, my lord.
If I do not block it and you upload whatever the process is, you follow the process and you avail of them.
Yes, my
What
lord.
happens then?
My lord, then the supplier who is the recipient to whom I am issuing the invoices, his credit will be blocked. There is a measure that can be taken by the.
He use then ultimately somebody's credit. He also will be able to avail whatever he is.
But my lords, the urgency with
this logic.
Yes, my
you
lords.
extend it a little further. Then in that case, again, we come to the same point.
But my lords, if the pre-hearing is not given, what can happen? Like in our cases, we have been given 3 notices, my lord. And under which section? Under Rule 5618. Rule 5618 does not empower the authority to issue any notice. I'll demonstrate before my lord. I've already demonstrated by.
That is different.
So that is the precise argument that we are taking, my lords, because even with that has been cited in the circular also, and also while taking this final judgment in para 8.3, my lords, if I read 8.3, in view of the aforesaid discussion, we are of the considered opinion that the learned single judge clearly fell in error in coming to the conclusion.
8.3.
8.13, my lords.
8.13. Yes.
In view of the aforesaid discussion, we are of the considered opinion that the learned single judge clearly fell in error, coming to the conclusion that pre-decision hearing was not required to have been provided or granted by the respondents prior to passing the impugned order blocking the ECL of the appellants, and consequently, the said findings recorded by the learned single judge deserve to be set aside. And about the matter of urgency, my lord, I have attached a judgment. I have submitted an authority of the Honorable Supreme Court in Sahara, India case. And even in the
What is the process of availing ITC? How do you avail it?
My lords, we avail it through the GSTR 3B. We show our output taxes, which is coming in GSTR 1. From there, it flows to my GSTR 3 with output taxes, and I avail my ITC in my GSTR 3B. There is a column, table 4A. So in that column, I have to go and avail the particular month's ITC under 4A5, all other ITC. And this ITC flows to my electronic credit ledger. From my electronic credit ledger, I need to do an offset. Offset is a back-end process which happens from my credit ledger. The money gets adjusted, the output tax gets adjusted. So if my output tax is 1,000 rupees and there is an amount lying in my electronic credit ledger of 1,600 rupees, 1,000 is offset. So 1,000 from the credit ledger will be offset against my output tax of 1,000. 600 will lie in my electronic credit ledger. So that is the entire process, my lord.
Very good.
So, my lord, even the other judgments that have been cited in K9, like CV Gautam's case, has been also discussed in para 8.4.
8.4.
Yes, my lords.
Yes.
So, my lords, in CV Gautam, para 8.4, page 28, in the second line, in our opinion, before an order for compulsory purchase is made under section 269 UD, the intending purchaser, intending seller must be given a reasonable opportunity of showing cause against an order for compulsory purchase being.
Because this is permanent impairment of right. Their property.
Yes, my lord, but the similarity with my facts, sir, here also there was no provision for giving a show cause note, pre-show cause hearing.
No, but this has to be read in the context. Here, the right of the owner goes. He loses title to the property.
Yes, my lords.
In your case, mere blocking will not denude you of your right over the.
My lord,
you will, for the purpose, for the temporary period during which the blocking continues, you will not be able to utilize it.
But my lord, that has its heavy civil consequences. Why? Because Rule 59A, it says that Once my 3B is not filed for a particular month, I will be impaired from filing my GSTR 1 for the next month. So primarily it's a hinge, it's a total, I would say, attack on my Article 19 and Article 14 also. Because I am not able to continue my business at all, my lords. This is not only a temporary, and that's why, my lords, even in the circular issued by the department, they have taken cognizance of this. That it's a draconian measure. It has to be done after complete application of mine. It cannot be done mechanically. And therefore, how does a pre-decisional hearing help? Just it is shared in this particular para, my lords, towards the end. In this para 28 itself, my lords.
28.
Yeah, in the same CV Gautam's case only, towards the end, my lord. Again, there is no express provision in chapter 22C.
Yes.
Barring the giving of a show cause notice or a reasonable opportunity to show cause.
That
No,
is settled, Mr. Dasgupta.
Yes.
I'm not on that.
So-
the facts of this case, whether
my lords, because the judgments that have been taken up in the K9 enterprise matter, they have in detail discussed as to how the non-giving of pre-decisional hearing notice is taking away my right of facing a huge civil consequences. As was held in Olga Telgis matter, my lords, the commissioner could remove, but he was told that the power to remove is with an authority to see that no one is removed without giving an opportunity of hearing. Because, and the argument was also taken that, like this argument, it's an urgent step, it's a emergency step, or they will not be removed from the pavement, they'll stay on the pavement. But the argument that was ultimately taken is that anybody against whom an allegation is being brought, here an allegation is being brought that I've availed fraud, ineligible credit, I should be eligible to know what are the allegations against me. I should be eligible to answer to those queries. And the emergency, about the emergency aspect also, my lord, in the Sahara India case, this has been dealt in detail in para 28. It is on para 8.5, my lords.
yes.
Rules of natural justice are not embodied rules. The phrase natural justice is also not capable of precise. The underlying principle of natural justice evolved under the common law is to check arbitrary exercise of power by the state or its functionaries. So I am having an inspection investigation. There is a finding on 7th of July. Within 7 days, 14th of July, the proper officer who is carrying out the blocking, he has all my data, he has all my documents. Still, he is saying the documents are not available with him. He cannot counter-check that. And so it will be lying on his arbitrary belief whether he can do it or not. And therefore, it will bring a total haltage to my business to a certain extent. And again, in my lords, I've also attached the judgment of Sahara India. If my lord could go to the last judgment, my lord. Is, yes, my lord.
This support my stand. That paragraph. Kindly see.
Which paragraph?
8.5. Kindly see. By the green portion, the rules of natural justice.
Yes.
Yes, starts. Kindly see the portion which has not been marked. The general principle as distinguished from an absolute rule of uniform application seems to be that while the statute does not, in term, exclude the rule of prior hearing, but contemplate a post-decisional hearing, amounting to a full review of the original order on merits. Then such a statute is conceived as excluding the ordinary passing rule at the pre-decisional stage. So in support my case, this is my argument that statute has provided for post-decisional hearing. My land is thank you, brother. I mean,
No, I
this is my point, my lord. A statute with specific direction of post-decisional hearing would mean that it excludes pre-decisional hearing.
if my lord permits, I'd like to counter it. While I would like my learned friend to take the last line of the same paragraph. But the core of it must, however, remain, namely, that the person affected must have reasonable opportunity of being heard, and the hearing must be genuine hearing, not an empty public service. And if we take Sahara India, my lords, on the last judgment that I've attached, in the last, it is the last judgment, my lords, on page 10 of the judgment, para 23.
Page 10.
Para 23.
Yes.
We are also unable to persuade ourselves to agree with the proposition canvassed by the learned counsel for the revenue that since a post-decisional hearing in terms of subsection 3 of section 142 is contemplated, the requirement of natural justice is fully met. Apart from the fact that ordinarily post-decisional hearing is no substitute for a pre-decisional hearing, even for the language of the said provision, it is plain that the opportunity of being heard
is only in respect of the material gathered on the basis of the audit report submitted under subsection 2A and not on the validity of the original order directing the special audit. So here in our case, we are talking about the blocking of the electronic credit ledger. We are not saying the consequence there too. So for that, it is well settled that the principal audio alter partem can be excluded only when a statute contemplates a post-judicial hearing amounting a full review of the original order on merit. The upshot of the entire discussion is that the exercise of powers under section 142A leads to serious civil consequences. I have already demonstrated before, my lord.
But this condition is met as pointed out by Mr. Chakraborty. It is so, because later on, upon me filing a reply, they can definitely review it and reopen it if they so feel. That was the intent of Rule 86A.
But my lord, the harm is, firstly, the harm is already done. And in this particular...
It's been appropriated. It's just blocked.
Block for 1 year, my lord. So my entire working capital...
1 year, if you can satisfy, they'll open it.
No, I'll demonstrate to my lord that also, that, how this is being taken.
That is exactly sub-rule 2. Upon being satisfied that conditions for disallowing debit as above no longer exist, they will allow such debit. That is what they say. It's exactly that.
Yes, my lord.
Right in pointing out that.
But my lord, the pre-decisional hearing which is there, that will not be a substitute for the post-decisional hearing, because after...
But Mr. Chakraborty, you still remain to answer a question as to if there is a particular process which is to be followed by the RTPs for the purpose of availing it. And that process is not as instantaneous as it would have been in cases of bank accounts where it is absolutely at your disposal. You approach the bank, encash a check, walk away with the money. That is not the case here. Then why can't a hearing be given prior to that? You still have it in your hand.
It is a self-assessed practice. But it is not the authorities that doing something. It is I am assessing my tax. I am paying the tax according to my self-assessment.
No, but Mr. Chakraborty, my question is directed towards the immediacy. What is the that it has to be done? Because I can understand in a situation where, because in all such cases where hearing is excluded prior to an order visiting the person concerned with civil consequences being passed, the situation that is contemplated either by the legislature or by the convention is that putting the person on notice would make him aware such that he makes the passing of the order itself meaningless.
Yes.
Now here in this case, if that is not the situation, even after you pass, even after you put him on notice, it is not entirely upon himself to avail of all of it, whatever is there. Yes. Then in that case, what is the harm in hearing?
He is having an input tax of X according to his understanding, and he does not pay that. He pays after appropriating that X. According to me, he is not entitled that X at all.
So how will he appropriate? For the purpose of appropriation.
So that is the self-assessment. Because I am paying, there is the adjustment of his output liability. There is always the adjustment of output. That's why can you see section 80? Section 83 is very important.
My lord, may I counter to that, my lord?
Just
Okay. Section 83 was done.
53.
Margaret, kindly see, this is a case of provisional attachment. This is for also a year. Now the Supreme Court has now taken action for a year. Kindly see the original one. It is below question one. It is what was there. Why during the pendency of any process. So when the statute contemplates the situation when there is a proceeding in motion. Now it has now changed. Where after the initiation of proceeding. Because during the pendency, what happened was it went up to Supreme Court. Pendency means if after adjudication of the appeal, you cannot continue. Or the appeal, you cannot continue with an attachment of this nature. Now the language after the Supreme Court judgment, the language has been changed. Where after the initiation of any proceeding, when a statute considers two situations. If a proceedings are one initiate, I can attach. And a proceeding and contemplates another situation, I can block. Here, attachment is more grievous. Blocking is not so grievous. And this issue of urgency is Bombay High Court which I relied upon. This urgency issue is to be also decided by the post decision of stay. It was so urgent that we have to block it. So all these issues, what had fallen from my love, it all can be considered as a stage, because that's why there has to be a satisfaction. You see, 86, there has to be recorded in writing, and there has to be satisfaction. One of the satisfaction is there's urgent power, so urgent that it requires the blocking. These are all considerations. But this has to be a post decisional. But the authority is concerned, feels that the concerned person may be not be trustable. He may go to IB or many eventualities. But we do not know. But my learned friend is speaking possibly one eventuality. There are many eventualities that can happen. What one is supplier. Supplier go and love the supplier. Supplier goes away. But I have to hold someone for the revenue. Ultimately, I have to hold someone for the revenue loss if there is. So that all these considerations are to be considered at a post-decisional stage. That is what the rule says. Well, I cannot come in the way. That is the correct interpretation according to me. But there is no requirement of pre-decisional hearing. But this is not something so great that it requires a pre-decisional hearing. But my lordship would remember Menoka and the case 17 Supreme Court. There was a case of passport. There also said post-decisional hearing is required. Article 14 and 21 was read together. So question is, what prejudice he has occurred? Immediately, he can come to court and say 3 months has passed. I have not been given a post. That's a fair step. But today we are considering whether a pre-decisional hearing is a mandatory or not. That is what he is saying. He says it is mandatory. I say it cannot be. But this can be 1 or 2 days or 7 days, 10 days. He can file a reply and there can be an adjudication. But it has to be. But kindly consider 67 also in the statute says there has to be a satisfactory recorded in writing. Reason to believe. Reason to believe. But today this reason to believe is a personal satisfaction. There has to be some tangible. Whatever judgment coming from reason to believe income tax matters.
Subjective.
Subjective. Tangible. There has to be something tangible. There has to be something tangible. I accept that one. It cannot be a matter of force. But today, all these issues has to be decided post. Well, that is what I think. And what my learned friend 2 paragraphs here said out, which favors me, where the statute specifically provides a post-decisional hearing. Well, in the stage of adding to the order, we often come to portals, we often to come to include that there was no emergency urgent powers. We could not have passed an
That
order.
is one of the grounds for granting
48 hours not
urgency is.
There is no 48 hours because when I challenge the order 39 rule code, it means I'm accepting whatever the allegation is, but despite that allegation, they could not have interfered. That is the principle subject to guidance. I know. That to be true, then urgency is to be also considered. He can always come up and say there was no urgent requirement for this. But this can always be considered.
Yes, Mr. Das.
My lords, to the question of appropriation of the tax, I would like to say that I cannot make my output tax according to my personal will and whim. It has to be made to a third party because I'll have to raise it on a third party. So that is the first day. That entire ITC utilized by me within a day or within a month, that is not possible. It will depend on the business modality. Second, about the urgency, my lord, is rightly pointed by my learned friend Arvind Menaka Gandhi matter. The matter which was there is that what is the risk, inherent risk in not impounding the passport? That was the personal liberties to be taken out. Here, my lords, if I may ask myself, I am an entrepreneur who is filing all his returns, who has his principal place of business, who has everything in order. There is an inspection coming out. From the inspection, there are some findings which are subject to adjudication. And in the meantime, I've been found to be of imminent danger that I'll be flying off. But no such ground has been given as to why is it thought that there is this urgency of invoking this blocking of the electronic release.
Have to be informed about grounds. They are informed of.
No, I'll just take this. So that was not
the question. Question was whether before informing the grounds also you should be heard or not.
Yes, my lord. No, I'm saying why if the notice is not there.
Not be changing the goal.
No, my lord. What I'm trying to say is that since my learned friend has taken up Menaka Gandhi on the emergency issue.
We were debating this.
Yes, so that is what I'm.
You should be heard prior to you being informed about the grounds. Grounds are given known, made known to you.
Yes, my
lord.
lords.
You can always challenge them saying these are not good.
Yes, but so if pre-decisional hearing is given, my lords, I can always answer to those allegations that are there in the mind of the officer and I can set it right. Now,
there has to be a
an adjudication process. Recently, my lord, someone at 86 says that I did not adjudicate.
Yes.
But these are all interim. It's adjudication is there. But there is full-fledged adjudication. There's an opportunity of hearing. So, but there's no prejudice. At least, when I do not see any prejudice on the face of it.
My lord, on this particular point about that adjudication urgency, I've already demonstrated before my lord as to how 3 notices were filed. 3 notices were issued. It's on the last page, my lord, of this. 3 notices were of the first submission that I've given, my lord. Yes.
Yes.
It's there in the writ petition also. I've just taken it from there. So, if my lord sees that 3 notices are issued. First notice issued on 16 July. I submit my reply on 7th August. Again, a notice issued on 12th August. I submit my reply on 22nd August. The day I submit my reply, again a fresh notice is issued under Rule 5618 on 22nd August. So, if there was this intent that I will be adjudicating the matter on a proper basis, this delay inherently would not have happened. That is my first submission, my lord. So, this gives an... No.
Well, let us not change the whole post. Whether there is
But
a requirement, what my learned friend says, takes out an example and says he is aggrieved by a particular situation.
Yes.
Mean that the pre-decisional hearing is required. But
No,
that cannot be a ground for pre-decisional hearing.
No, what I'm trying to demonstrate before my lordship is, if this pre-decisional hearing was given, I would have given a reply and the proper officer would have given it a speaking order as to why the electronic blocking has to be done. Now, since the pre-decisional hearing has not been given, firstly, he is issuing me orders under a wrong provision. Rule 56.8, which is not there. And secondly, I would like to counter the point made by my learned friend on comparing it with section 83, my lords, provisional attachment. So he says that it's a parameter to a provisional attachment.
No. He's saying 83 is graver.
Yes.
This is not as grave.
So even in 83, my lords, if we see, where after the initiation of any proceedings under, so it's after the initiation of proceedings. And as we have seen in the armor security judgment in para 72, it has already defined what is proceedings, it's show cause notice. So even if I go by that particular judgment, my lords.
That does not come here. 83, this minor says inspection. That chapter is also included. Armor did not take in consideration section 83 because proceeding definition. Here it considers a situation when inspection notice is given. That is also a proceeding. Can you see 83? But that was not taken into consideration. No one pointed out to the Supreme Court. 83, the language is chapter. Can you see which are the chapters which includes? Chapter 12. Chapter 12 is assessment. Assessment stage also the Supreme Court is the provision saying proceedings. Now this has to be inquiry proceeding, not an investment. 12.
14.
14. Can you see what is 14? 14 is
Inspection. Yes. Sorry.
Inspection. So, Supreme Court 74 it says one of these proceedings. There is some kind of dichotomy, if I can say, between this.
My lords, but all the 3 chapters are included. Proceedings will be for all 4 chapters only.
No. You will have to read the judgment in the context of the facts.
Yes, my lords.
Armor is on a different 74. Armor says from 74.
That was for section 6 purposes. So that will not be relevant here.
Okay.
I was showing the statute has given an opportunity that where after initiation of proceedings.
Yes, Mr. Dasgupta, next.
My lords, if you want, we can have it on another day. As you are saying that there are other matters.
Yes, you continue for some time. Let us see if you have some other judgment, what else, so that you can substantially advance.
Yes. My lords, we have also taken the judgment of Xiaomi and Radhakrishna Industries.
Page.
In Xiaomi also.
This is not paginated, no?
No, it's... No. My lord, the Xiaomi judgment on para 12 and 13.
It's not paginated. That's why it's getting difficult to find.
Third last judgment, my lord. Third last. My lord, just before Olga Tellis.
Yes. Your Honor.
My lords, in para 12 and 13.
And 13.
In the instant case, a perusal of the impugned order will clearly indicate that the same is arbitrary and reflects premeditated conclusions without recording either an opinion or necessary to attach the property.
This is by the same court which rendered this L9, K9, whatever.
Yes, my lords. Yeah, but it is only earlier to K9, my lords.
Yes, but
yeah, by the same bench.
Following the same logic.
Yes,
so it's only multiplication of what was already there. Any other court?
My lords, in the Sahara India, and my lords, I would also like to.
If you see the trend, if you see Xiaomi.
Yes, my lords.
The honorable judge who passed the order was presiding over the division bench in K9.
Yes,
it's the same thing.
My lord, even in
High Court has done that. No. Any other High Court has?
Other High Court, yeah.
No other High Court. No other.
No, I think they have Pilcon actually.
In this compilation, there is none. Only these two are there.
Yeah, yes, my lords. We have given the other Supreme Court judgment, my lord, like Sahara.
Those are on different points, not on this.
Not on this, my lords.
Nobody has pronounced on this except this.
My lords, Allahabad High Court has done.
Followed.
I had Bombay, but these are on supporting facts. I had about 4 or 5 them.
দিদি এগুলো আলাদা করুন সব সঙ্গে আছে আশাপুরা
Yes, my lords.
Ashapura ISKCON.
My lords, in all these judgments which are referred to there, these are all regarding the electronic credit blocking on the negative side. That negative credit blocking cannot be done. They have not mainly handled with the issue of pre-decisional hearing, my lords. If I may stand corrected by my friend. This was the judge. This is just
19 I've seen.
Same compilation, my lord, given by my learned friend already. This is the same compilation.
I have it.
Yes.
Earlier than DP was not considered, but I have also handed over DP.
DP you have handed over, paragraph 35.
Yes, that is prior to this Kannada judgment, which was not considered.
And my lord, also another thing I missed to demonstrate before my lord is the circular.
Circular?
My lord, in the compilation, the circular that is given.
Yes.
My lord, in para 3.1.4.
Yes.
It is reiterated that the power of disallowing debit of amount from electronic credit ledger must not be exercised in a mechanical manner, and a careful examination of all the facts of the case is important to determine case fit for exercising power under Rule 86A. So by the very power, it's being told that it has a huge civil consequence, and therefore it should be done on a limited and a narrowed version. And the other judgments that have been shared, as I have shared, my lords, those are mainly on negative blocking of the credit.
When can we meet next?
Next week, my lord. 11th. My lord, on the 11th.
How long will you take, Mr. Dasgupta?
My lord, that next, take not 20 minutes.
What was this matter?
My lord, your lordship has heard it, my lord. I think on 2 or 3. My lord, the matter is that an adjudication order has been passed. And in the show cause notice, the allegation was that against the 3 suppliers, my lord, who had supplied me goods, that they had issued fake GST invoices in fraudulent manner without actual supply of goods. But my lord, on this account, the adjudicating authority could not bring any evidence, except the fact that she had relied upon, my lord, certain truncated portion of the central authorities, my lord, directions, circulars, alleging that they were not there, but the full is not, full text is not there. My lord, kindly come to the show cause notice at page 86.
Yes.
86, ma'am. It starts with from the GST database records, the RTP such and such, that is the petitioner here, having GST such and such, has availed ineligible ITC from cancelled and non-existent suppliers. So there are 2 parts. One is his registration has been cancelled, and another allegation is that they are non-existent. Then, my lord, the next part, the RTP RVN Recycling Metals has obtained ITC such and such from Apex Industries, who is accused of passing on bogus ITC in a number of registered taxable persons. Apex Industries was engaged in issuing false GST invoices in fraudulent manner without actual supply or movement of goods. ITC enjoyed by RTP is thus not allowable, as the transport and movement of goods is practically impossible from a supplier who does not have any physical existence. Now, my lord, the allegation is the supplier, Apex Industries, has supplied fake invoices to some other dealers. And it is assumed that because it was not transported, not specifically in respect of me, so it is impossible from a supplier who does not have any physical existence. So, my lord, there are allegations that his fake invoices have been issued to a number of dealers and he does not have any physical existence. Now, my lord, kindly see what are her evidences. She has given the invoice string from my database, and there are 2 invoices, my lord. The dates are, or 3 invoices, 4/4, then my lord 7/4, and I think it was 7/4, 6/4. No? What is this?
8/4.
8/4, my lord. No, but no, these are the invoices. Now, my lord, so if your lordship sees, the transaction had taken place on April on 3 dates. My lord, I was very much, my registration was valid. The supplier's registration was valid, and the supplier had also submitted his returns showing the sales, and my lord, he has also paid the GST which he has recovered from me by way of tax, the tax through 3B. Now, my lord, and my lord, kindly see what is her evidence. Kindly come to page 88, my lord. Only a truncated portion. Oh, my lord, this is only a screenshot of something and truncated. The whole thing is not there. And on this, she is making the allegation that they have issued me fake invoices and they do not have an existence. Now, my lord, this was given at the show cause stage. My lord, at the final, when the order was passed, a more legible copy was annexed, my lord, which is at, I think, page 330. Now, your lordship will see what is there. My lord, this is what the CGST authorities are writing.
Page
330, my lord. This comes, my lord, this full legible copy and the full text of whatever she annexed is annexed at page 330, but it was not annexed with the show cause notice. Yes. It says request for cancellation of GSTIN in respect of Apex Enterprise. And my lord, it is 21/7/23, much after the transaction with has been done with me. And they are saying that you cancel his registration under section 29(2). My lord, section 29(2), if I may place that particular provision, nowhere states that registration is to be cancelled for non-existence. My lord, there are separate provisions for cancellation of registration for 29. So all I'm trying to say, my lord, that she had no evidence that fake invoices have been issued to me and that I never existed. Because, my lord, if they were to cancel my registration for non-existence, my lord, section 29(2) says, A says, my lord, if a registered person has contravened any provisions of the act, then what provisions of the act has been contravened, that has to be stated. Then, my lord, a person paying tax under section 10 has not furnished his return. That is not my case. Any registered person other than a person specified in class B has not furnished his return. My lord, that is also not my case. And then comes D. Any person who has taken voluntary registration under subsection 3 of section 25 has not commenced business. That is also not my case. And a registration has been obtained by means of fraud, willful misstatement, or suppression of facts. My lord, nowhere it says that the registration is to be cancelled for non-existence. But my lord, under the statute, there is a provision for which the registration can be cancelled for not doing business and for issuing fake invoices. That is, my lord, Rule 21. Yes, ma'am. It's 21. My lord, kindly see, my lord, Rule 21. Registration to be cancelled in certain cases. My lord, A, does not conduct any business from the declared place of business. Issues invoice or bill without supply of goods. So, my lord, the central authorities have not proposed to cancel my registration under these grounds. If there was a specific finding that I did not exist, or I suppose I issued fake invoices without supplying goods, then they ought to have taken a proposal to cancel my registration, which they did not do. Now, my lord, similarly, this is for
what has been done in your case?
My lord, nothing. They've only said that the central authorities had said cancel the registration under section 29(2). Nothing more. But she is assuming that I did not exist and I have issued, not I did not exist, my supplier did not exist, and my supplier had issued fake invoices to others. No specific finding that fake invoices have been issued to me, but therefore it is to be assumed that they never did any business there, and therefore there has been no transportation of goods to me, and I have not received the goods. Now, my lord, it's similar matter for other two also. On this basis, she has, and my lord, in all these cases, my lord, all these suppliers were registered at the relevant point of time. They had submitted their returns in and GSTR 1, which it has been auto drafted in my GSTR 2A, and on that basis, my lord, the tax which they collected from me, the suppliers have also deposited with the government exchequer. So, my lord, having received the tax from my suppliers, it cannot be said that they never did business. On the one hand, their tax is being collected from them, which they have collected from me. And then they are saying, my suppliers never did any business. Now, my lord, to this, I filed a reply. Or reply to that, reply. I think page 88, 86. So I filed a reply. Yes, page 86.
Page?
I'm coming, my lord. 95. 95. My lord, 95, my lord. My lord, I annexed all the documents in support of my claim. And my lord, I'm specifically page 95, it starts. I'm specifically, my lord, drawing your lordship's attention to page 96, B. My lord. My lord, may I read, my lord? Page 96B.
96.
96, my lord.
B.
3B.
Yes.
My lord, I have stated that the physical verification of the RTP as noted in your show cause notice, DRC 01, are not in accordance with Rule 25 of the GST Rule 17. My lord, Rule 25 says that if any inspection has to be made, the Rule 25, my lord, that inspection report has to be uploaded on the portal so that people could, that it would be seen, it will be
But madam,
transparent.
why would you not approach the appellate authority?
Yes, ma'am. Because yes. My lord, on the earlier occasion, this also fell from a lordship. I produced all my documents. She admitted I have produced all my documents. She said that I have produced to show the movement of the goods. I have produced my e-way bill. She said, yes, e-way bill has been produced, but it cannot be decided. You could have uploaded the, unloaded the goods in the middle.
For showing the movements of goods, only e-way bill is sufficient.
Yes, my lord, that is the law, my lord. And I am also in this matter, my lord, judgment. My lord, this is my judgment. My lord, I'm relying on Allahabad High Court's judgment, my lord, that what is required. My lord, হ্যাঁ নিশ্চয়ই তোমাকে দেবো না তো কাকে দেবো? এই 29 বার করো। 29. My lord, in this matter, similar thing. It was, the case was like us. They were not allowing their ITC, and they produced the e-way bill. And my lord, page 29 of the judgment. I'm only relying upon the ratio. My lord, that e-way bill is sufficient. Only to that extent, my lord. Page 29 of the judgment. My lord, page, sorry, my lord, para 29, page 5. Page 9, page 9. My lord, may I read? My lord, no, my lord, it has been categorically stated there, my lord. They said that we want toll tax, evidence that there has been a movement of goods. We want to, what are the toll gates through which it has passed. So, my lord, may I read?
Yes.
Further, an inference has been drawn against the petitioner that the petitioner has failed to submit the toll plaza receipts in order to justify the actual physical movement of the goods. The said finding is patently or apparently perverse and is without any basis. The revenue has failed to bring on record any provisions or rules under the GST Act as well as rules which compel the SSE to file toll plaza receipts in support of actual physical movement of the goods. On the contrary, e-way bill, bilty, and tax invoice was produced. And my lord, they showed their payments made to the transporter. So my lord, it is the e-way bill, the tax invoice and the bilty, which is the consignment note, my lord, which comes when from interstate, my lord, when the goods come, they have a consignment note called bilty. Yes. Yes, my lord, all this. And my lord, in the judgment, my lord, 323, in her order, she is telling me entry pass documents, stock register, weighing slips, delivery challans, truck receipts. All these are required for showing evidence of movement of goods. My lord, page 323, my lord. And then, my lord, she says that the e-way bill, yes, they have produced all the documents. Yes. 320. What is the matter?
Yes.
So she's asking that, first of all, she never asked, saying Toll Plaza or Madam, can you come to page 323 with the order?
Yes,
Madam,
323.
323, Madam, in fourth paragraph. Producing e-way bill as proof of movement of goods does not mean that the recipient has received the goods. My lord, it is only on conjecture. The noticee has failed to prove and establish beyond doubt that he is in possession of valid tax invoices. My lord, I produced.
It's 3, original side. When can we come next?
My lord, I will be.
We had actually, we had more or less concluded. My learned friend, I had at length I had argued this matter because this e-way bill, with deepest respect, to remember that matter was so Mujumdar e-way bill was was downloaded, but he had a different movement. It doesn't prove it's a
But
declaration. I'll just rely, but for my law satisfaction, I just rely on some judgment. Kindly, if Malad comes back tomorrow, Malad.
Tomorrow it may not be possible because then one matter continues.
Yes. My
No, the first week of March.
That's what I got.
First week of March. Again, I'll forget again the entire thing because this happened last time also.
Yes. My lord, I'm also, my lord, I'm leaving on 6th. I'll be out of station till 20th, my lord, of February. My lord, I'm very sorry.
I have come to 24.
No, you all will complete thereafter. I will have to, that becomes difficult.
And my lord, this is I'm relying on the same judge's judgment.
It was supposed to come on 14th because you all were in difficulty on 17th of December. And from 14th, it's there in the list.
17th
by the traveling. My lord, I'll be traveling. My lord, I'm from 20th, my lord, actually.
Tell me when. I don't have
up to the first week of March, I said. Because
March is too long. Entire February we are.
My lord, 23rd, 23rd February.
23rd, I'm out of hospital.
কোথায় আছে? 24th,
23rd, 24th.
26th,
26th,
27, 26. Then
my learned friend is enjoying us basically. We are not taking any steps.
My lord, let it be recorded, my lord. Let it be.
All these days, nothing has happened. I heard Miss Mukherjee, learned advocate, appearing for the petitioners. Full stop. For continuation of her arguments, comma, list this matter once again on. I am fixing it in February only. Ask for an adjournment. It
Yes,
won't look
my lord,
nice. March.
My lord, my
It
lord.
doesn't make any sense.
My lord.
On on 12th February.
I'm okay.
But my lord, I may not be, but while
if you're not there, you prefer.
Yes, ma'am. I'm grateful, my lord.
The same judge previously has hold different judge, but that judgment has that judge say
My lord.
এটা দেবেন তো আমাকে বাড়িতে দিয়ে দেবেন
My lord, only thing, my lord, since may I humbly pray, my lord, till such time, my lord, they should not.
For all these days, it has not been there. Suddenly.
All right.
My lord, there should be 10% deposit.
Hey, no, no, you. My lord, the
17th
second,
order.
my lord, the second is similar, my lord, a different year.
17th একটা রিটটা দিন একটু কপিটা দিন 17th
My lord, Canodius matter, it's the Jyotitar matter. matter gets decided, or this is
That was on show cause ground.
This is not an adjudication, but this is also there is an appeal trial. And whatever my
Oi,
management has
same order.
argued, that's a factual dispute.
No, I'm only saying that she did not consider my documents.
Very well. No. Next.
I'm grateful, ma'am.
Any mention in the original side? Good application number, item number 1.
On the last occasion also, of January, nobody attended. Just because 23 November.
देखिए.
Milord, kindly grant us a passover. Milord, my senior is engaged in some other court.
Passover. Passover. What? Not today. Not today.
Grateful.
Next.
Item number 2.
We are same matters, you know, that. Can it be in March or otherwise? So after 10th of March. My lord, I am appearing for the petitioners in matter number 2 and 3. My lord, the judgment in which anticipation we were in, it has been passed, and I have the order here, my lord. But Lord, I would like to pray for not today as the leading counsel, my senior, he is not well.
What is the judgment?
My lord, it's Union of India versus Aspen Petrochem.
देखिए.
Yes.
Which one was yours?
My lord, it is, if we see in the first page, from where it is written 501, it is civil appeal number 4559. My lord. Just above that.
4559.
Right.
This one was yours.
Yes.
I mean of the revenue.
Pick it up.
Just a minute. Just. So 4559 has been remanded to
Right.
Festat.
Yes, sir.
So it's open. So ask him to come tomorrow then. Tomorrow he'll be okay.
My lord, any time after, on Friday or after Friday, my lord. Next week.
Monday actually. I'm not passing any order. It will appear on Monday. So it's लिखे नहीं next order लिखे. An adjournment is prayed for on behalf of the petitioner.
in this matter, Your Lordship, it was last heard on 12th of November. I will quickly recapitulate, Your Lordship.
You are appearing.
Your Lordship, the order impugned was passed on 10th June 2022, Your Lordship. And Your Lordship, the time to prefer an appeal is 60 under Section 128 of the Customs Act is 60 days, and beyond that 30 days, Your Lordship. Your Lordship, petitioner had not preferred any appeal within that time, and the department also took no steps for enforcement of the order. Only on 30th May 2025, they issued two recovery notices, Your Lordship, one against the petitioner and one against the partnership firm, because, Your Lordship, in the order also penalty was imposed twice, once upon the petitioner and once on the petitioner's partnership firm. And although the allegation is that the petitioner was in control and he has, whatever allegation is there is against the petitioner only. So, Your Lordship, on the last occasion, Your Lordship, I have made a summary, just quickly recapitulate what was argued. I will give my learned friend also. And then, Your Lordship, my learned friend had taken the point of maintainability, which, Your Lordship, I will answer that and then continue with this.
Yes.
Your Lordship, the first point, penalty imposed twice over partner and on firm, which is not sustained in the eyes of law. And Your Lordship, these two judgments I had cited. That, Your Lordship, penalty cannot be imposed on the partnership and the partner both. Then, Your Lordship, the second point.
Yes.
Yes, Your Lordship, that finding that onus of physical verification lied on the petitioner, this is also beyond the, it is not the duty of the petitioner under the law. And on that point, Your Lordship, I had cited a division bench judgment in the case of Sun Glory, Your Lordship, Commissioner of Customs versus Sun Glory. And I had also referred to the regulation, Your Lordship, that was point 2. Third point, Your Lordship, the finding regarding KYC non-verification, this is contrary to record because I had checked all the KYC documents. So, Your Lordship, I had referred to my reply where I have said that I had checked the KYC and KYC documents I have also annexed. Your Lordship mentioned the page numbers. And Your Lordship, under this heading, the third point was that reply of the petitioner to show cause was not considered. This is in violation of natural justice, Your Lordship. Fourth point, Your Lordship, that allegation of overvaluation against the petitioner custom broker is not sustained in law. And Your Lordship, in similar case, court held that when the valuation of the given by the valuer is not accepted by the department and department makes their own valuation, which is identical to these facts, then the custom broker cannot be held liable, Your Lordship. That judgment I had cited, a division bench judgment of our High Court, Your Lordship, reported in 2023 386 ELT page 523. Your Lordship, this I had cited on the last occasion. Now, Your Lordship, for appointment of valuer on the instruction of the representative of importer, no adverse inference can be drawn against the petitioner, Your Lordship. Your Lordship, this on this, Your Lordship, I had referred to the pages showing that each of these valuers were impaneled with the income tax department, Your Lordship. And Your Lordship, I had appointed it from the list, and why it's shown page 163 to show that there were various valuers, not one person was appointed. Your Lordship, then Your Lordship, collection of bill and payment to valuer. Your Lordship, I had cited a circular that this is the normal trade practice. Custom brokers incur expenditure from their pocket and they then get reimbursed, Your Lordship. On that, I had cited the circular, and Your Lordship, delivery of goods to this person called Sanjay Chaudhary was as per the instruction of the importer, and therefore no inference should be drawn. And Your Lordship, at that stage, my learned friend appearing for the customs said that the rate should not be maintainable, Your Lordship, because Your Lordship, 2022 order, I am challenging in 2025, Your Lordship. So, Your Lordship, I will quickly answer that, Your Lordship. Before that, Your Lordship, there is a development in the meantime. Your Lordship, if Your Lordship takes volume 2, Your Lordship,
Volume 2.
Your Lordship,
I have it.
Your Lordship, I had shown that the allegation against the petitioner, Your Lordship, from page 239 onwards, the finding against the petitioner is from page 239.
Yes.
Your Lordship, I am emphasizing, Your Lordship, page 240. Your Lordship, last paragraph.
Yes.
Your Lordship, there is a finding. I find that there are corroborative evidence in the form of examination orders, statement of not only the government approved valuer, but also the statement of Shri Ashok Chando, partner of Chatterjee and Company, wherein they have admitted that the government approved valuer was chosen and appointed by them only. Next paragraph, page, Your Lordship. The custom had further enhanced the CIF value by 8% approx to the value given by the valuer. And Your Lordship, I'm placing the next paragraph. These government approved valuers are also notices in the subject show cause notice and have been charged with conspiring to keep the assessable values at par with the declared value. So Your Lordship, there's an allegation that I am the broker in conspiracy with the custom valuers, the impanel valuer, Your Lordship, the valuation was inflated. And Your Lordship would take next page 242, Your Lordship.
42.
Your Lordship, just after the table, investigation reveals that Shri Amit Bhuturia, Your Lordship, he is one of the valuer, has connived with Shri Ashok Chando of MS Chatterjee and Company. That's me, Your Lordship. So, Your Lordship, now what has happened? In the meantime, Your Lordship, we have come across a judgment passed by the learned SISTAT. Your Lordship, the Custom Excise Service Tax Appellate Tribunal, Your Lordship, is the last fact-finding authority. After that, the appeal to High Court is only on question of law. So, Your Lordship, in this appeal, which was filed by Amit Bhuturia, Your Lordship, I just placed the valuer with whom I had allegedly conspired. Your Lordship, there's a finding that there is no such conspiracy. Your Lordship, I will just mention the paragraphs I would like to place. Your Lordship, paragraph 2.1, Your Lordship. One, Your Lordship. Your Lordship, here also it is quoted, during the course of investigation, the investigating officers came to the conclusion that Shri Amit Bhuturia, a government-approved valuer, had connived with Shri Ashok Chando of MS Chatterjee and Company, Your Lordship. This allegation was made. And Your Lordship, the ultimate finding is, Your Lordship, in paragraph 9 and 11. Although, Your Lordship, I want to rely on some more paragraphs. May I place it serially, or Your Lordship?
When was this order passed? The order in original?
Your Lordship, 10th June 2022.
And why have you approached in 2025?
Your Lordship, the petitioner has given the reason in page 31. Your Lordship, his wife is a cancer patient. And Your Lordship, he is the sole caregiver. Petitioner is also a senior citizen, Your Lordship. And
31.
Page 31, Your Lordship, of the writ petition. And Your Lordship, there are 6 orders passed against him. The total penalty against him is over 20 crores, Your Lordship. Your Lordship, he was traveling to Chennai every 3 months with his wife, Your Lordship. And Your Lordship, the petitioner is challenging the recovery notice also, Your Lordship, which came only in 2025, 30th May of 2025. Writ was affirmed on 21st of June 2025, Your Lordship, within 20 days of receipt of recovery notice. Your Lordship, here, Your Lordship, the dispute is between, Your Lordship, what the petitioner is challenging is only personal penalty, Your Lordship. The dispute is between the petitioner and the government, Your Lordship. There is no case of a third party right or any change of circumstance. And Your
Can
Lordship,
you make out a case of inherent lack of jurisdiction here?
Your Lordship, if Your Lordship, this is a chain. The allegation is that I have connived with the valuer, I have paid extra consideration to them, and they have given enhanced value, which has resulted in certain undervalued goods being allowed for import. So, Your Lordship, in the chain, if the valuer is now exempted, is discharged with a finding that the valuer has not taken any extra consideration, and he has not connived with me, then Your Lordship, how can I now be punished? Or Your Lordship, this writ may be considered on that ground itself that the entire chain is now broken. Secondly, Your Lordship, even DRI had also initiated, the case was started by DRI, Your Lordship. Now, Your Lordship,
This order is not on record. You bring it on
I
record.
will bring it on
for
record.
Supplementary then.
Your Lordship, I will bring it on record. Today, Your Lordship, should I continue, Your Lordship?
You can.
There are other points also, Your Lordship, because DRI had initiated this case. Apart from proceeding against me under the Customs Act, Your Lordship, which is challenged here by imposing a penalty, they had proceeded against me by a criminal case also, where DRI has dropped the case against me. Your Lordship, this is not the case where...
That is on record.
On record, Your Lordship. That is on record, Your Lordship. At
That
page
was done when?
362. Your Lordship, before filing of the writ petition.
But after passing of the order in original.
Your Lordship, Your Lordship. So, Your Lordship, they have chosen to drop the criminal case against me. And Your Lordship, under the CBLR, Custom Broker Licensing Regulation, there were 2 cases filed against me, one for suspension, one revocation. One I have been discharged. The other one is pending, Your Lordship. So, Your Lordship, I can place this order on record. In the meantime, Your Lordship, that will also, I think, Your Lordship, conclude. And Your Lordship, one judgment was cited on the other in another case before Your Lordship, the Gujarat High Court 3 judgment decision that even if the writ is beyond time, even if the appeal is not filed, if the order is beyond law, rules, and procedure and in violation of natural justice, Your Lordship, the writ can be entertained. That one,
There is no problem, but
Your
if
Lordship.
the delay is inordinate.
And Your Lordship, on delay also, I was carrying one decision, a recent judgment, where the court, Your Lordship, said that when the dispute is between the state, it is not that third part. The matters should be decided on merits. And
for that, appellate authority is there. There are judgments to this effect also that if you have a statutory remedy, then at least reasonably you should approach the
Your Lordship, Your Lordship, I remember, Your Lordship, I refer to a 61 judgment. Your Lordship, I know that. But Your Lordship, here, Your Lordship, the petitioner is a senior citizen. His wife is a cancer patient. Now, Your Lordship, there were 6 cases started against him simultaneously. And Your Lordship, he was also being prosecuted under criminal laws. And Your Lordship, he had no financial capacity. For 21 crores, Your Lordship, I have a chart to show Your Lordship the total penalty on him. Chart. Your Lordship, he must have resigned to his fate, Your Lordship, with this kind of penalty, Your Lordship. 7.5%, Your Lordship, was impossible. Your Lordship, by the when this matter was taken earlier, before Justice Raja Basu Chaudhary, Your Lordship.
I have this chart.
Your Lordship. He had said, Your Lordship, that if required, I should produce my balance sheet. So, Your Lordship, that also I'm carrying, Your Lordship, to show that I had no financial capacity also. So, Your Lordship, if we take the entire matter in a holistic manner, if we see, Your Lordship, then Your Lordship, the matter may be considered on merit. May I, Your Lordship, cite the judgment on limitation, Your Lordship?
That's settled. You can cite it, definitely. Cite it if you have to cite it.
And Your Lordship, I can come back by after filing a supplementary, Your Lordship. Your Lordship, this is a recent judgment, Your Lordship. Your Lordship, from paragraph 14 onwards, Your Lordship. Your Lordship, here the delay was 1500 days. In my case, Your Lordship, it is approximately 3 years, Your Lordship. And Your Lordship, I'm also challenging the recovery notice.
This is for application of section 5.
Your Lordship, and but
The
Your Lordship, here
parameters are
the
different.
principles from writ jurisdiction has been drawn. I will place the specific, Your Lordship. Your Lordship, from paragraph 16.
Yes.
Your Lordship, the court in Ramchandra Shankar Deodhar versus State of Maharashtra held there was a delay of more than 10 or 12 years in filing the petition since the accrual of cause of complaint. And this delay contended the respondent was sufficient to disentitle the petitioner to any relief in a petition under Article 32 of the
32
Constitution.
is different. It's the
Your Lordship.
fundamental right petition.
Thereafter, Your Lordship, 226 is also discussed. We do not think this contention should prevail with us. In the first place, it must be remembered that the rule which says that the court may not inquire into belated or stale claim is not a rule of law, but a rule of practice based on sound and proper exercise of discretion. And there is no inviolable rule that whenever there is delay, the court must necessarily refuse to entertain the petition. Each case must depend on its own fact. The question, as pointed out, Your Lordship, then this judgment is cited, is one of discretion of this court to follow from case to case. There is no lower limit, there is no upper limit. It will all depend on the breach of the fundamental right and the remedy claim are and the remedy claimed are and how the delay arose. Your Lordship, here I will become remediless. And Your Lordship, I have no, because Your Lordship, now that SK Chakraborty judgment is also, Your Lordship, court cannot extend time. So the only option is a writ petition. No doubt, Ramchandra Shankar Deodhar relates to a writ petition, but the statement of law laid down is clear. Has also considered the impersonal nature of functioning of the state. Your Lordship, under paragraph 17 only, in collector versus
Katiji, famous judgment.
Your Lordship.
Land acquisition judgment.
Your Lordship. The court noted that it had been adopting a justifiably liberal approach in condoning the delay and that justice on merits is to be preferred as against what scuttles a decision on merits, albeit while reversing an order of the High Court, therein condoning the delay, principles to guide the consideration of an application for condonation of delay were culled out. One of the factors taken note of therein was that substantial justice is paramount. Next page, Your Lordship. Your Lordship, here it is being considered in the context of Article 226.
You file your supplementary?
Your Lordship.
File your supplementary. How soon can you file?
Your Lordship, I can file it. Your Lordship, in all the 6 writ petitions, I'll file separately, Your Lordship.
Yes, you have to file separately.
Your Lordship, within a week, Your
You
Lordship.
use an opposition to this. How soon can you file? No, opposition to the writ petition definitely will go through the order also.
Your Lordship, the writ petition is admitted, Your Lordship.
I'll give them opportunity to file because there is delay, so they must have this opportunity to file opposition to the writ petition also.
Sure.
Otherwise, I would have disposed it off at motion stage. It won't be proper.
Yeah.
You take all your grounds, whatever grounds you have.
Your Lordship, the only problem is it doesn't come. There are matters where more than 1 year has elapsed.
No, till such time I am here, it will come.
Your Lordship.
Only ground that
You take that ground also because she has an explanation also to offer for the delay.
And remember that if we are giving an opposition on the list, because the entire deputation is in the form of an appeal, then we have to go into the merits completely.
You will take the point of take the point of maintainability on the ground of delay as well as on merits. I'll adjudicate both. I will not adjudicate one of the two. Since it's here before me, I'll have to adjudicate both.
Your Lordship, I can also supplement the medical documents, Your Lordship.
Yes, you can always do. You have your chance in reply, you have your chance in supplementary, whatever, so that.
Grateful, Your Lordship.
All issues with what matter. If my valid friend is ready or your lordship is convenient to.
I'm grateful to your lordship.
So here the matter is related. Should be it's still in the motion stage. There is no direction to file any opposition earlier. Only for that reason, the small issue is involved, Your Lordship, in this matter. This matter is related to assessment year 14-15, Your Lordship. After going through with the 148 AB, AD, and all, considering the judgment of Honorable Supreme Court, Ashish Agarwal, and all those things, one writ petition filed, which was dismissed. Thereafter, the appeal is filed before the Honorable Division Bench. The Division Bench, what considered in appeal, Your Lordship, I'm just showing that it's page 67, Your Lordship. I'm not showing that judgment directly. One portion of that in which
page
67, Your Lordship. I'm not showing that judgment, Your Lordship. That judgment as portion, it has been stated in the 148 AD, which I have already challenged here. So it's a page 67, Your Lordship, which you can find out 3rd of May 23, Your Lordship. It's a 148 AD order passed,
Yes.
Your Lordship. Here what happened? They have mentioned all the. It's a page 68, Your Lordship. Next page. The SEC company filed a writ petition bearing such and such. The Honorable Calcutta High Court in due course affidavit in opposition, such and such filed. And this writ petition, Your Lordship, it's a dismissed. It was not considered, Your Lordship. Thereafter, further, Your Lordship, the next paragraph, the SEC has filed an appeal before the Calcutta High Court on division bench, Your Lordship. Due to course of affidavit, opposition has filed. The Honorable High Court, the Honorable Calcutta High Court wide order dated 2nd of September 22, Your Lordship. Kindly mark that date. 2nd of September 22, Your Lordship. Disposed of the appeal, such and such, by stating following observation. The order passed under section 148 AD of the Act has been set aside on a technical ground that it is based on certain investigation report which was not furnished to the SEC, and such allegation did not form part of the show cause notice. Therefore, if the department has material in hand and if the law permits, Your Lordship. Whole question, whole discussion is related to if the law permits. Nothing prevents the department for proceeding further, and for such purpose, no liberty is required to be specified granted by this court, Your Lordship. As such, there is no extension of time, nothing, Your Lordship. Simple, the observation was that if the law permits, that order was not challenged, nothing was there. Thereafter, what happened, Your Lordship? It's the 2nd of September 22, this order passed. Now, what they have done, on 26th of December 22, they issued the 148 AB, which was totally time barred. There's no question about that. The assessment year 14-15, there was no extension of any time. And not only that, it's a time bar. The thing is that there was no another material in record their hand. They did not just given, further they did not given that on 148 AB, Your Lordship. And thereafter, what happened in the meantime,
for
during the Your Lordship 148 AB,
14-15, what
they
was the time
issue,
limit?
Your Lordship, 14-15, Your Lordship, it's a 6 year. It's on 21.
Not 10 years.
It's not 10 year, Your Lordship. It's a 6 year or 21. After just considering the certain COVID period and all, the 6 months more time can be extended, which was not extended in various observation and all. Your Lordship. And other part of that, Your Lordship, despite of that, simultaneously they have issued the 142-1 in the meantime. They issued 148 AB and they issued the 142-1. Once we have replied to 142-1, that it's clearly mentioned the earlier 148 AD was set aside and department has to initiate the fresh proceedings. Instead of that,
no, in 2023 it was 10 years. 149-1 AB. 3 years, not more than 10 years.
Your Lordship, it's a assessment year 14-15, Your Lordship.
Yes.
Your Worship, we will consider that once earlier they have issued the 148 AD.
So that
Your
was,
Lordship, it
that
was in 21, Your Lordship.
that was set aside on technical grounds of you not providing information, not for the purpose. It was not set aside on the ground of limitation.
Your Lordship.
It was set aside on the ground that the allegation that was leveled did not form part of the show cause notice. That was all.
Your
Now it
Lordship.
says that if law permits, if the law permits means it should be within limitation. So it was 10 years.
Your Lordship, the order passed of 2nd of September 22, Your Lordship.
Very well. So 2014, 15, 10 years is 2025. If the notice is issued in 2023, it's well within
Your
10,
Lordship, on 20, later on, Your Lordship, it's on, I think it's 10 year is there in the year 23, Your Lordship, not prior to that. It's
No, 14, 15 will be 2024. Why 23? It's rightly done. Limitation, it's not bad by limitation.
Your Lordship, thereafter, Your Lordship. Simultaneously, Your Lordship, 148 AD they have given. 148 AB on 26th of December. Thereafter, on 27th of February 23, Your Lordship, they issued the notice of 142-1. Previous proceedings, they again initiated.
Where is the first order of 148 AD?
Your Lordship, I'm sure. Your Lordship, it's at page 38, Your Lordship. Your Lordship, the technical issue was there. They have that stated that we have received a such and such amount from the company Tridev Infra, which we never received. This was the one of the technical ground of this notice. There was no material in their hand, and the thing is that we have never received any fund from the Tridev Infra, Your Lordship. We have stated that whatever amount we have received with the Culminating Management Private Limited.
The initial notice was issued on 19th of April 2021.
Your Lordship.
Therefore, that notice was within time. If
That
even
notice
if,
was
even
within
if
time.
the unamended 6 years is
Your
concerned.
Lordship, 6 years is
So
considered.
if that was within time, the next notice which was issued upon withdrawing the earlier in terms of this Ashish Agarwal judgment, that will also be within time.
Your Lordship.
So this is a sequel to that. So how will this be barred by limitation?
Your Lordship, thereafter, after just interfering by the division bench order, Your Lordship.
Division
That
bench set it aside on the ground of non-supply of material. That they
material,
have
Your Lordship.
supplied.
Your Lordship.
That they have supplied. Initial notice which was issued in 2021,
Your Lordship.
and then the separate notice which was issued in 2022. That notice continues. There is no fresh notice under 148 AB issued.
Your
Only
Lordship.
material has been supplied. The
Your
notice
Lordship.
continue.
Your Lordship.
The show cause notice under 148 AB was not set aside.
Earlier, Your Lordship.
Yes. So
But
the show
once
cause notice remained of
148,
that date only.
Your Lordship, that was if that notice is continue, Your Lordship,
Yes,
then they
you are
have
right
to
that
continue with
148
that.
also has been set aside.
Then they have
Yes,
to
Mr.
continue with
He
that,
has
Your
a
Lordship.
point. 148 is now freshly issued. That will be time barred.
Your Lordship.
148 notice, which was set aside by the division bench, that is freshly issued. This 149 will apply not to 148 AB but to 148. Yes, but you were said that if you can issue if you are entitled to issue in accordance with law. On the day when you are issuing the fresh 148 notice, on that day you are not entitled to issue in accordance with law.
Your Lordship.
Order 2nd September 2021, page number 45.
Yes, I have seen that. I have seen that because the court did not say that the period will be excluded. Now, for example, suppose if a 2014-15 matter is there, can you issue a notice today? Or on the date on which you issued this notice, when this notice was issued? Earlier notice, presumably you cannot, this notice was issued on 3rd of May 2023. 3rd of May 2023, within 10 years will come after 2022. Your proceeding is prior to that.
Your Lordship. And not only that, Your Lordship, thereafter, they have again issued the 141 proceedings, Your Lordship, considering the previous notice. Only they are just taking it in a
23 matters, no stay was granted. So what they have whether 142 if they have not participated in the assessment or have passed or not that time.
Your Lordship, we participated in 142.1. We have replied that thereafter they withdraw that. Your Lordship, they withdraw that notice, considering the fact, because they have wrongly issued 142.1. Because they have issued the wrongly 142.1 issue. That's why they withdraw. They have to issue the fresh proceedings. They try to escape the fresh proceeding, considering the fact there is a time bar. That's why they try to just issue the 142.1, considering the previous 148 AB, Your Lordship.
When can you come? Tell me.
Last occasion also, this was only that he has to come with the instruction. That's why it's on the motion itself, Your Lordship.
Mr. Dudh.
Item number 10.
I am for the petition. This writ petition was filed on 25th July 2025. Thereafter, it appeared, my lord, for consideration on various occasions, my lord. The department took time to, my lord, that they have filed the appeal against this estate's order.
Yes, yes.
My lord, still it is pending, my lord.
What
They have
happened to that appeal?
nothing.
Mr. Dev was there.
So I actually before the appeal for I think the article record. Although the appeal appearing in the list monthly. Probably it will give you this month by
Let us wait, Mr. Dugar. Let us wait. Likhen it is submitted that the appeal listed, how can I touch that?
And
It
below
won't
the,
be
below,
improper.
and appeal is below threshold limit, my lord.
That the division bench will set aside immediately. I'll take up then.
Good.
हाँ क्या बोल रहे हैं
12:13 Mr. Subhash Agarwal is appearing. He does not want to continue this matter today, and Mr.
हाँ
Rajat
हाँ 2-3 दिन
health is not well, so I'm praying for adjournment. 11, 12, and 13.
Yes, very well, but
Not
when,
today.
when can?
Not today. Just
No, today will not be possible. An adjournment is prayed for on behalf of the petitioner. Full stop. तीनटे matter is same.
deeply placed one.
Item number 14. Item number 14.
थोड़ा सा. Same. अच्छा 14, sorry. लिखे नहीं.
But Mr. Dev instructed my lord to appear in this matter.
Petitioner is not there. None appears for the petitioner.
Item number 15.
If they were there, I would have requested them, but nobody is there. Asking it to appear on 10th, nobody is there. Same order করে দিন. ওই রেসপন্ডেন্টদের রিপ্রেজেন্ট নোট করে নেবেন রেসপন্ডেন্ট স্যার.
Item number 16.
You are there. Nobody is there.
My lord, I am for the customs, my lord.
You are for
Customs.
customs. Same order করে দিন এটাও.
Item number 17.
Nobody is appearing. What is the problem? Same order.
Item number 18.
And for the petitioner, Your Lordship. Your
Yes.
Lordship, in this matter, Your Lordship would remember that Your Lordship was about to remand the matter and then.
Oh, yes,
Mrs.
yes.
the
Miss
court-
Mukherjee was there.
Yes, Your Lordship. Lordship. Your Lordship. She was here, Your Lordship.
Yes, she was there.
My lord, I am for the customs.
Yes.
I with Mrs. Mansi Mukherjee.
Your Lordship, she had placed page 181.
Yes.
Your Lordship, I would just address the point which she had raised on that occasion.
You had admitted something.
Your Lordship,
that
yes,
sort was
exactly, Your Lordship. Your Lordship, I will address that. Page 181, volume 2, Your Lordship.
Yes.
So your lordship, this is my statement.
Yes.
Your lordship, kindly see the date of the statement, your lordship. 20th February 2024.
Yes.
Yes. And your lordship would kindly take volume 1 with this, your lordship. Your lordship, volume 1, page 72.
72.
Yes, your lordship. Your lordship, your lordship, here your lordship would find in two places, your lordship. In the middle, your lordship, Roman 2.
Yes.
Your lordship, he took, your lordship, this is the transporter. He took a telephonic order from Sri Sachin Tiwari, son of owner so-and-so, on 24th January 2024. And your lordship, towards the end, your lordship, same page, last point, he admitted that he had transported the goods in container to CFS Transworld terminals on 24 January 2024. So your lordship, I want to show the timeline. Your lordship, the shipping bill was filed on 23rd of January. And your lordship, this on the basis of, your lordship, as per the show cause itself, your lordship, I'm showing the show cause only. Your lordship would kindly take page 62. Your lordship, this was also from the show cause, page 72. Yes, your lordship. Your lordship would find, your lordship, last three lines, the good declared as energy drink as per packing list. The said consignments were meant for export to Balaji Foodstuff Trading, UAE. The details as declared by the exporter. Your lordship, this is the details are given by the exporter, invoice and packing list. On that basis, I have filed the shipping bill. Now, your lordship, the table, your lordship, shipping bill number and date. Your lordship, all the 5 shipping bill is filed on 23rd January 2024. Your lordship, shipping, I have now, your lordship, coming back to my statement, which my learned friend had placed. I would like to, your lordship, quickly place the entire page 181 from where my learned friend was reading. So your lordship will get the entire picture. Your lordship, I got the KYC documents on 20th January. I got the invoice and packing list on 22nd January. I filed the shipping bill on 23rd January. Goods were transported to CFS on 24th January. And your lordship, at CFS, the customs examined the good on 29 January. That your lordship will find at page 63. Your lordship, may I again give the dates, your lordship? Your lordship, 20th January.
KYC on 20th January.
22nd January, I got the invoice and packing list.
22nd,
20
invoice. Shipping bill on 23rd.
23rd.
CFS on 24th.
Goods were transported from to CFS on 24th. And your lordship, from page 63, your lordship will find that the goods were examined on 29th of January. And this statement of mine is dated 20th February 2024. Now, your lordship, I quickly place the statement, page 181, volume 2. Your lordship, he has no direct contact with the proprietor Sahil from KSH International. He was told about the exporter by Shri Hariom Mishra, alias Pradeep Mishra, addressed at so-and-so, who introduced himself as the dealing hand of the exporter and would help in providing all export document of KSH International. Your lordship, I had filed the supplementary showing that I had all the KYC, and KSH represented that this person is their dealing hand in Kolkata. On 20th January 2024, Shri Hariom Mishra provided all KYC documents such as authorization letter, custom information sheet, signature verified by bank, cancelled check in the name of KSH International, PAN card of Sahil proprietor, and GST registration certificate to his office. This is all there in the supplementary. It was referred to in my reply. After scrutiny of the documents, he collected invoice cum packing list and other relevant documents from Hariom Mishra, alias Pradeep Mishra, which was necessary for filing the
Where are you
shipping
reading,
bill.
Mr. Chaudhary?
Page
Where?
181, your lordship.
Yes.
May I place it from?
No, I've got it.
Roman 3, your lordship.
3, yes.
Yes. On 22nd January 2024, they were provided with 5 invoice cum packing list for shipping bills in the consignment. in the subject consignment along with signed copy of the FEMA declaration certificate. After observing all formalities, they filed the shipping bill on 23rd January 2024. So, Your Lordship, in the show cause also that it is admitted that shipping bill filed on the basis of the packing list. This is never the allegation that I knew that the goods were misdeclared or overvalued. The allegation is that the diligence was not up to the expectation. Your Lordship, as per the officer, it was not to his expectation, which Your Lordship, I had relied on judgment that physical verification is not required, etc. Now, Your Lordship, Roman 4, he has no connection with the subject consignments movement before coming to the CFS Transworld Terminal Private Limited. Your Lordship, I am not concerned with the movement. Transporter had transported it. And Your Lordship, this happened on 24th of January, after the shipping bill was filed. And my role comes to an end after I file the shipping bill. As per Hariom Mishra, alias Pradeep Mishra, the container was stuffed at a local godown and moved towards CFS Transfer Terminal Private Limited. The deal of rupees 2,000 was fixed for their service charges, agent charges for handling this consignment, which they yet to receive from exporter. He had verified IEC from, he had verified, Your Lordship, he, I think is referring to me, had verified IEC from DGFT website, verified GIS TIN from GST website, bank details provided by the exporter were itself verified by bank. However, it is impossible to verify the functioning of his client at the declared address since the exporter is a Ludhiana, Delhi-based merchant trader. On this, Your Lordship, remember that judgment, Your Lordship, that physical verification is not required. The goods declaration, point 7, Your Lordship, this was placed, Your Lordship, on the last occasion. The goods declaration as per invoice cum packing list was energy drink under, Your Lordship, this is the classification. He had nothing to say about the goods since he had not seen the goods earlier. However, upon examination, now Your Lordship, who examines the goods? Your Lordship, customs examined the goods on 29 January 2024. And Your Lordship, thereafter, everybody knows that it is overvalued. I also know. It no more remains a secret. However, upon examination, there is contradiction with the declared item for which the exporter can explain as the exporter is directly related to goods. He had seen the website of Hamdard and in his opinion, the unit price declared is overvalued and too high and unreasonable. This, Your Lordship, happened subsequently. I am coming to give statement on 20th February 2024. So, Your Lordship, subsequently I verified and found it overvalued. And even examination had already taken place, Your Lordship. Thereafter, Your Lordship, everybody knows it's overvalued. So, Your Lordship, just because he said that, yes, it is, there's a price difference, this cannot be culled out and said that he knew at the time of filing of the shipping bill that it was overvalued. Only examination, Your Lordship. He says that.
Where is the exact question and answer put to him? Because this is paraphrasing.
Your Lordship, Your Lordship, I can give that, Your Lordship. And Your Lordship, just to complete this point, Your Lordship, the allegation in the show cause notice is never that I had access to the goods. Your Lordship, the goods are in a container. In the customs, it came from a warehouse, it was loaded somewhere, stuffed, and then it came in a container to the customs, that is CFS station. And there it was examined. I had no access. And this is not the allegation in the show cause notice or in the order, Your Lordship.
Where is the show cause?
Your Lordship, show cause is at page 61, Your Lordship.
Yes. Where is the allegation?
Yes, Your Lordship. The allegation against me is at page 90 and 92, para 8.2, Your Lordship.
8.2. Yes, I've got it. Failure to perform due diligence.
Your Lordship.
So even if you had known the price of the goods, was there something which you could have done?
Your Lordship.
In terms of due diligence?
Your Lordship, there are judgments. One of them I had cited that valuation is not my domain. Your Lordship, what is the duty of the custom broker? On the basis of, we check the KYC. Your Lordship, KYC includes GST registration, import-export registration, which are issued by the government authority. So, Your Lordship, if there are cases where the importer is not, or the exporter is not found at the real address. There also, Your Lordship, courts have held that it is not the duty of the custom broker to physically verify. The government authorities who issue these licenses, they should verify. The custom broker is only to see the KYC. Which, Your
So
Lordship,
can it be your submission that even if he had known the goods in terms, known the valuation in terms of this, there was not much that he could have done?
Your Lordship, that is,
In
Your
terms
Lordship,
of due
I
diligence?
had no knowledge. That is my point. And Your Lordship, that would be
No,
again.
but this does not show that you had knowledge subsequently. This only shows that you had knowledge, whether before 20th of February 2024
Your Lordship,
or on 20th of February 2024.
Your Lordship, Your Lordship, I will take Your Lordship to
It's
my actual
dicey to
statement.
come to a conclusion on the basis
Your
of this only,
Your
because
Lordship,
the
this is not today, Your Lordship. What is under challenge? The order impugned is under challenge. And Your Lordship, this was never the allegation that I knew from before. The allegation, Your Lordship.
No, that is why my question is, if you had known from the before, then how would that have affected your due diligence exercise, or that would not have affected at all, or it was irrelevant?
Your Lordship,
Which
then
of?
they would have attribute here. I am charged for omission and commission that I have not. Your Lordship, there are two aspects. If we see section 112A, or here penalty has been imposed under 114. Your Lordship, one is in case of custom broker, one is that omission and commission is for the parties who are engaged in the transaction, and abatement is for the person
who facilitates
yes,
it.
but Your Lordship, here the allegation is not that. Here the only allegation was that I should have physically gone, and Your Lordship.
Show me that first.
What is my allegation? Page 90, Your Lordship.
Page 90. The allegation is you miserably failed to perform due diligence.
Due diligence. And the allegation is omission and commission, not abatement. If I had known, Your Lordship, then I would be an abater. For omission commission, no intention is required. Para 8.2. May I place it, Your Lordship? Shri Sudipto Bose, custom broker, Bose Enterprise, being authorized custom broker, failed miserably to perform due diligence. In this case, by accepting export document from an unauthorized person, Shri Hariom Mishra, without making any further effort to check for the genuine existence of exporter, it is the obligation of the custom broker to advise his client to comply with the provision of the Act. However, Shri Sudipto Bose failed to perform his duty as per custom broker licensing regulation. Failure of the custom broker would have otherwise allowed the fraudulent exporter to take place, fraudulent export to take place, resulting in substantial loss to government exchequer in the form of export benefit, which exporter was not eligible to claim. Hence, hence for this act of omission and commission, which rendered the impugned export goods liable to confiscation under section 113, the custom broker custom broker Bose Enterprise appears to be liable to a penal action under 114(3). So, Your Lordship, this is the entire allegation against me. And Your Lordship, the finding, Your Lordship, page 208. And Your Lordship, 114(3) is not applicable to the custom broker because it relates to valuation. That judgment, Your Lordship, I had placed before the authority. He had not considered, bypass the tribunal's order, and Your Lordship, this judgment was passed. Your Lordship, I had placed, Your Lordship, should I show the statements, Your Lordship?
Yes, once.
Yes, Your Lordship. Your Lordship, page 131. Your Lordship, this is my first statement, Your Lordship, dated your
21st of October.
Your Lordship, this is Your Lordship, this is the subsequent one. The first one, Your Lordship, at page 153, volume 2, Your Lordship.
153.
153.
153.
May I place the statement, Your Lordship?
All these statements are not required. I wanted to see the question to which the answer was given.
Your Lordship.
It's question 10, page 156.
Your Lordship. Your Lordship, he was shown.
Page 156.
Yes. The answer is more relevant apparently against the exporter.
Your Lordship, I have not been charged as a abettor. So I had no knowledge intention. The only thing they have said is due diligence, which, Your Lordship, may I again place the relevant paragraph of the judgment, which was, Your Lordship?
Yes, Ms. Mukherjee. This shows that this is not relevant. This question was in a different context. If you see the just earlier question, you see from question 9 at page 156.
Question number 2.
Page
Page
156.
154.
154. 154. Yes.
The question for the license holder, it was explained. How did you come across the exporting firm KSH International or its proprietor Mr. Sahi? How did you get all the documents for filing of shipping goods mentioned? I had no direct contact with the proprietor Mr. Shani or the firm KSH International. In the second week of January, one person and everyone Mishra, Pradeep Mishra, having addressed the tower, 65 rather Amon Roy Road, South 24 Parganas, West Bengal, all that had been told about the it was discussed that energy drink exported as told by Mr. Davis to someone. Harimo Mishra or David Mishra, he would be his hand open and help in providing the food around 20th January 2024. Exactly the December, Harimo Mishra provided our office to all the KYC documents of the exporter such as authorization, customer information sheet, cancel check, national vanguard of studies, GST registration. Then, after scrutiny of documents, I collected invoice from packing list and other relevant documents from Hariom Mishra, which were necessary for filing of the shipping. So that has been his answer, what he has done at all as a customs broker. So that as a customs broker, you have knowledge I know that a customs broker has to undergo examination for obtaining the license. Why did he undergo the examination? All these questions are put that what are the obligations and values that the customs broker, what are the expectation of the department from him. And as a customs broker acts on behalf of the customs department, sir, not on behalf of the exporter. Duty to perform due diligence as a prudent man would be in his position.
But how does this answer become relevant here? That the price was high, this answer does not.
And it is his submission also that he has accepted the documents from a third party, not knowing the input. So whether the scrutiny that he has been as per due diligence expectation of the due diligence, that should be the question.
So according to you, accepting documents from a third person was an improper act on the part of the customs broker.
Next, what would be that, why we are here? We are here because an adjudication order has been passed against me, not before that. What would be the consequence of a negligent act of a customs broker? The consequence of a negligent act or non-performance of his duty would amount to a revenue loss which will be more than 1 crore. Now I will explain through the adjudication order how he has done.
Why was this referred to? This that he had knowledge on the last occasion you referred to this, because of which page 181.
181, last paragraph.
Yes. How is that relevant in the facts of this case?
When that was recorded, where it has taken. It taken the recording.
Yes, but you said that he knows that the price was overvalued. So how is that relevant now in the context of this case?
If I know a bunch of paper is 10 rupees and I let it go for 100 rupees and again I am paying exemption and we can draw back on that, and I am the agent or the exporter, then of course I am not performing. You cannot be with the closed eye. You cannot perform it with the eye is closed. He is there as a customs broker. So that knowledge he should have. The customs broker goes through the examination after we like today. Today I submit what I file a document for Milord and I am the AOR. I accept the brief from a third person. But I find the Bangala norm of filing. Now tomorrow that document is fake. Can I say that I accepted from a third party because the client is coming to me who is filing as a party? So whatever I have done, I have not done my duty properly. I have accepted the brief. Now can I just forego my liability? I have to be honest with the court and say this has been happening, and I have to help the court to find out what wrong has happened. Because I cannot escape my responsibility just by closing my eyes and say that I have accepted it from third party. It is not. My department is asked you to accept it from third party. If you have done it for your some professional benefits, that you have done it. For that, I will go after you because the exporter will not be found. Some of the issue. A lot of money as a drawback exporter was yet to go, from the government exchequer. Since this has been got on the process, provisional release was allowed. The bond and the duties have not been paid in it. So while payment the duty, he didn't come forward and take the goods. So that is the fact. What is everything comes on an implication of somebody's non-performance of duties and liabilities. So we have only I've got the non-performance of the duty. So kindly consider page 179.
$179.
1.3, paragraph on the first paragraph.
Yes.
On going through the export documents and the data in IPA, it was found that the exporter export incentive claimed by the exporter was rupees 1,37,138.09. including drawback amount of 31,647 and RODTEP amount of 1,05,491. The difference between the rate printed on the goods and the value declared in shipping was very high. This raised doubt about the genuineness of the export consignments of the same shipping bills by KSH International. Hence, considering anomalies noticed in the matter, including subpart value of the goods, detailed investigation against the export consignments of KSH International was initiated. That is
Your Lordship, who will get the benefit? If there is any export benefit, the exporter will get, not the custom broker, Your Lordship. Your Lordship, whatever the client affirms on the affidavit, Your Lordship, if the client affirms a false statement on affidavit, the client will be penalized, not the advocate, Your Lordship. The advocate's duty is,
Let her complete.
Your Lordship, to see that the client is present and he
We'll
signs.
come back
Your
to you.
Lordship.
Yes.
On examination of the state container, two kinds of drinks have been found. The first type of crates were found to contain 24 pieces of peach colored membrane fed bottles, each having level quarter energy. The crates were moved one by one along counting to the 396 crates of such energy drink were found. Upon putting in the this is very relevant. No sticker was found. What? The customs department officials can see, you could not see as a customs store. No sticker was found on the crates of the first type of drink. However, on the neck of the bottles were found printed batch number this, MRP this, for export only mirror. So that creates a suspicion itself. The second type of crates were found to contain 24 pieces of transparent 180 ml PET bottles, each having red color drink label and blue of the red brush. Upon counting total 2664 such crates of drinks, two crates were found. Gross weight of each of such crates found to be 4.86 kg. On examination of the second type of drink, the crates and bottles were found to have been dirt, stains, scratches, and appeared to be old. The crates were found to have stickers pasted on them, which internally read as MRP 480, batch number 6, date of manufacturing, in many of the crates, the portion of the sticker where MFG and used by dates are mentioned were found to be torn off. However, on the neck of the bottles, it was found to be written as MFG, EXP, this and this for export, which appeared to be contradictory to the description mentioned on the stickers pasted on the crates. This is not all. Then we are so, Milord, if clear suspicion will arise in the mind of the man and going through the consignment and the batches of the bottles and the crates. Milord, next, Milord. 181.
Yes, yes.
Milord, 181 is 1. Para 2.2. Under para 2.2, personal details were being voluntary statements. Or Roman 1. We had no direct contact with the proprietor, Shahil, or the firm KSH International. He was told about the exporter by Hariom Mishra, alias Pradeep Mishra, address at CDP Tower, and the West Bengal village, who introduced himself as being hand of the exporter and would help in providing all the export documents of Mrs. KSH International. On 20th January 2024, Hariom Mishra provided all the KYC documents, such as authorization, consumer information sheet, answer check with the name of KSH International, PAN card of Sri Sahil, proprietor, and the GST registration certificate to his after scrutiny of documents collected in welcome to the next thereafter the very said the goods declared as per invoice and packing list was energy drink.
Yes.
Under RITC, this number, he had nothing to say. He had nothing to say about the goods since he had not seen the goods earlier. However, upon examination, there is contradiction with the declared item for which the exporter can explain as the exporter is directly related to the goods. Nobody is saying he is related to the goods, but he is related to the exporter. He is an intermediary. A recognized, authorized intermediary to act on behalf of the customs officials or the customs department that will take to perform that acts that a customs official would have done because it is to facilitate business.
Very well. When can we meet next?
Your Lordship, we can complete it tomorrow, Your Lordship, since Your Lordship,
Depends.
Your Lordship, it was last heard on 21st January. Your Lordship were about to remand the matter, and Your Lordship.
I can otherwise kindly be not to get
Your Lordship, tomorrow, Your Lordship.
লিখে নিন অর্ডার টেন আর সাবমিশন গুলো রেকর্ড করেন আর নালে ভুলে যান and I'll just think about it. লিখুন Miss Mukherjee, learned advocate appearing for the Miss Mukherjee, please correct me. You have Ms. Chaudhary have gone through your submissions which were recorded last the last order.
Your Lordship.
Anything else?
Your Lordship.
I'll be adding up whatever you
Your
said.
Lordship, only that Your Lordship, evaluation is not my domain. I can supplement with further judgments on the next day, Your Lordship.
লিখে নিন Miss Mukherjee, learned advocate appearing for the only for this matter. I'm doing this because I have done it in the first round, so her submission should also go. Otherwise, I would have just recorded her.
Or Your Lordship, we can
Learned advocate
tomorrow, Your Lordship.
appearing for the respondent customs authorities submits that the petitioner has miserably failed in performing the due diligence exercise. Full stop. It is submitted that the very fact that the petitioner has accepted documents from a third party and not from the exporter is an indicator that the petitioner has abdicated his duty. Full stop. Ms. Mukherjee draws the attention of this court to the findings of the adjudicating authority at paragraph 1.3 of the order in original and submits that the steep difference in the rate printed on the goods and the value declared in the shipping bills raised suspicion. Full stop. Referring to paragraph 1.4 thereof, comma, it is submitted that the on scrutiny it was found that on scrutiny no stickers were found on the crates 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 of the first type of, within inverted commas, within brackets, 250 ml pink colored bottles of drinks although on the neck of the bottles it was printed that the same were for export only. Full stop. The various anomalies indicated in paragraph 1.4 of the adjudication order were also placed before court. Full stop. Paragraph. She also referred to the voluntary statements made by the petitioner on February 20, 2024 within brackets at page 181 of the writ petition to submit that the petitioner had knowledge that the goods had been enormously overvalued. Full stop. Paragraph. Ms. Mukherjee submits that a customs broker always acts for or on behalf of the customs department, and as such a high moral obligation is to be discharged by customs broker. Full stop. It is submitted that in the case at hand, comma, the petitioner has miserably failed in discharging his duty.
Answer to question number 2. Where he admits that he has accepted it from a third party, and then he says after it is a direct statement.
Yes, I said that third party. একদম ওপরে যেখানে লিখেছেন একদম ওপরে লিখে দিন যেখানে লেখা আছে না that he has accepted documents from third party, দেখুন একদম ওপরে লেখা আছে স্টার্টিং এ যেখানে স্টার্ট করলি third party. In such regard, comma, in such regard, she invites the attention of this court to the answer given by the petitioner to question number 2 of the voluntary statement recorded under section 108 of the Customs Act 1962, comma, on February 20, 2024. That's it.
Documents, not goods, Your Lordship. He never handled the goods.
Acha, it is asserted that it is clear therefrom that the petitioner has scrutinized the documents. Full stop. You are continuing still. How long will you take? No, not today. Whenever you continue, how long will you take? More. Miss Mukherjee continues. Full stop. Now, ওটা কেটে দিয়ে লিখুন for continuation of submissions of Miss Mukherjee. List this matter once again on when? Tomorrow? This is continuing, that's why we could have.
Is Monday, any day, any other day this week, if not tomorrow.
No, let's be firm. Then have it on Monday. Monday you will be there.
Monday.
My lord, kindly record my appearance also.
Yes. Your name to record. Monday on 9th. February 9th.
Grateful, Your Lordship.
Grateful, my lord.
Thank you.